Good
documents.
morning. Good
I got
morning,
documents.
everybody. We're live again. We're live again.
Good morning, y'all. How is everybody? Did you get your bellies full on the donuts and bacon and
Apples,
eggs?
apples, and apples. Check out Eric's new avatar.
Yeah.
I was like, what is that? Is John Pryor between loin fire? You know, is that like two pieces of meat? So it looks like. And then he said, no, it's two apples. It's an apple and an apple. It's the middle of an apple. Because he was saying what, Eric?
Pryor was complaining yesterday that the state was getting 2 bites at the apple. So I had to poke a little fun at him.
Well, we always that's how we cope.
Right.
Don't put yourself there then, John Pryor.
That's right.
Anyways, Jason, turn your phone down, please. Thank you. I'm like, you can stay in here, but you gotta be quiet. Because it's very distracting. It's not anything to do with him. It's anything goes off in my peripheral, and I'm like, huh? Oh, and there I go. Okay. See, that's that insta karma I'm talking about. That's it. You see how fast that is? Huh? That's how this goes around here in my family, from my world. It's like, oh yeah, here you go. This is for being snarky. Boom. All right. So, y'all, I have after last night or after the hearing and everything yesterday, I did a little bit of some more research, and then we ate, and a storm rolled through, and then I fell asleep until this morning. And Jason woke me up without, trying to put me in a panic. And he was just like, okay, yeah. And he had to remind me that we have court this morning. And I was like, oh, crap, I didn't even schedule it. So I was doing all that this morning and everything else. And anyways, it was just crazy. Hold on. I'm looking at my email. Oh. Eli. Well, Eli sent an email, and it's a video, a YouTube short. This is probably unrelated, but I couldn't help notice the proximity of Rexburg and Yellowstone to this spot. I wonder if this has to do with the 50-mile zone of death that bothers me.
I'm sure it does.
I'm sure it does too. And then also would love to bring that up in court when we're able to give a victim impact statement.
Mm-hmm.
Yep, this is on the death. Where murder is legal. Not legal, but it's this 50-mile zone of death is what they call it. And it's literally right there by Rexburg. It's by Yellowstone. It's right there. I'm gonna say in your backyard.
When that came out back when the kids were still missing,
right?
That blew me away. That
it's mind-boggling, right? So, right. I mean, it's mind that I was just like, oh my God. There's no people that live there in that area. It's because it's a national, federal-owned land. It's federally owned, state park, state land. Well, it's between I can't see. Montana is between Montana and Idaho, and it's this little strip. It's a little sliver. And I'm gonna go look it up real quick so we can watch it, if y'all don't mind, because I really do feel. Do we want to wait on the next missing people to be like, oh my God, there's on death? because it's weird, and I don't like it. I don't think there should just do away with it. Make it all federal land or whatever. There's got to be a way. Let's see. Okay, talk amongst yourselves.
How's everybody in chat today? Everybody's super excited about this severance motion.
So excited. Everything slides on this damn thing. YouTube.com. Oh, come on, mouse. Very slow. And I have it so small over here. Hold on. Let me go big. Go big or go home. Okay. Let's just take a little look. As soon as I get to it, of course, I'm just trying to talk because I feel like I need to. I don't want y'all to think I'm ignoring y'all or being rude.
No, you're good. I'm just, I apologize to the chat because I'm supposed to be filling the air, but
I can feel it.
I'm checking the Amber Alerts that we're gonna talk about here in a little bit.
I'm not quick with the keyboard, guys. I'm like ding ding. Feature. I need to turn on turn on my do not disturb mode. 5G feature. Share. Okay. Cheese and rice. That was long. Okay. We're about to learn about the zone of death. Buckle up. As soon as we get there. Come on.
Buckle up.
What the heck? Nothing? This is weird. Oh, let me just type in zone of damn death. Zone of death. Short.
And it's amazing that hasn't been resolved. You know what I mean?
Yeah. It's a
that issue.
Okay,
I mean, that's
just a second. Okay, now let me share and okay.
Did you know that you can make a full-time income from YouTube without
I'm not signed in.
You're fine.
So I'm not used to that. I'm like, what?
Is in Wyoming. It extends a bit into Montana and Idaho. This little 50 square miles section in Idaho is what concerns us. It's called the zone of death because of a loophole that exists in the Constitution of the United States. If someone were to exploit that loophole, they might be able to get away with murder. Yellowstone was established in 1872 before Wyoming, Idaho, and Montana joined the Union. It's federal land and always has been. But federal land across the U.S. is split up and divided into its corresponding state district courts, except for Yellowstone. And this is where the loophole begins. Law professor Brian C. Kalt points out in his 2005 paper, The Perfect Crime, that Yellowstone National Park was assigned fully to Wyoming's district court, even though small portions fall into Montana and Idaho.
So, unlike every other district, the District of Wyoming includes land in other states.
So, Kalt asks the question, what happened Mile, Idaho to Cheyenne, the hub of jurisdiction. But Article 3, Section 2 of the United States Constitution says that the trial should happen in the state where you committed the crime. If you're a savvy murderer, you'll invoke your right to a trial in Idaho. So they bring you back to Idaho, no big deal.
In the Sixth Amendment, they said that they would require local juries. And the language they used is that the jury has to be from the state and district where the crime was committed.
This is called the vicinage clause. That leaves you with this sort of Venn diagram. You have the right to demand a jury from that middle area, where the state in which you committed the crime, that's Idaho, overlaps with the judicial jurisdiction where you committed the crime, the Wyoming district that has jurisdiction over Yellowstone National Park. And here's the problem.
Nobody lives there. There's no way for them to give you a trial, and so I argue they should have to let you go.
This could also happen in the Montana portion of the park, except a few dozen people do live there, so a jury could theoretically be called. CULT has proposed numerous solutions to Congress to fix the loophole, but they have yet to act.
All they have to do is redraw the district lines so that the District of Wyoming is Wyoming, the District of Idaho is Idaho, and the District of Montana is Montana.
Seems simple.
And if they do that, this all goes away.
So if you're planning a gathering of your adversaries, exes, and debtors, maybe try Yosemite.
So there's that. Now let me try and figure out how to get the hell out of here. Wow. So that concludes today's presentation. No. Hold on. I'm still new to this, y'all. I'm trying to figure out the layout and all that good jazz. About to mess with y'all's eyes. Boop, 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 boop. Okay. So isn't that crazy? That's some crazy
I
stuff.
don't know. Like I said, I don't know why.
It's a loophole.
Yeah.
You learned something today, Jake-A's mom? Yeah. Yeah, today is a motion to sever the cases. Yeah.
And
Yeah, I'll go ahead and I will go ahead and put that link in there for y'all, for us.
I would say, I think I already said it, but I'll say it again. We can expect, or I would be expecting a lot of breakouts in this hearing because there's no way they can talk about this severance without talking about Lori and her, where she's at. So, I mean, I'm just guessing, but I think that there will be a lot of breakouts in it. So, unless hopefully they worked it out, before starting the hearing, that would be really great. But
yeah, I never know what to expect. It's like I don't comprehend it right away. I'm just like, I don't know what happened. Somebody tell me what happened. So that's what I love about this community, is that that's how I learn. This is how I learn. Every aspect of it and stuff. What was it that did you discover something last night?
Yeah, that's what I was getting ready to say. It was just like yesterday. I completely missed what was probably the biggest bombshell in the whole dang meeting, or the whole hearing. And that was John Pryor saying that he's not going to be arguing or pursuing removing Rob and Rachel in his motion to dismiss. I didn't even hear that until yesterday evening when I messaged you about it, because I went back and listened to the whole hearing again, because it's hard.
I haven't.
I'm not good at watching the chat and trying to listen to the hearing and trying to take notes. And I'm not good at all that. Doing
Right.
it all, trying to do it at the same time.
Me
And
neither. Practice makes perfect.
to me, that was the biggest bombshell in the whole
Email.
hearing.
Email me, Robbie. Email me and I'll drop you a link in the email. If you don't mind. I'm sorry. Go ahead. I was just trying to fit that in.
That's all it was. It was just when I heard that, because it happened, he started talking about it about 25 minutes into the hearing. And I was just like, wow, how did I miss that? And
Yeah. I don't know. And a lot of people see things differently. And so that's really cool when they can bring up so many different angles, you know?
yeah,
And that's how we try to fill in the blanks. So yeah, Robbie, if you will, just email me at Kresha, KRESHA0123 @gmail.com. And that way I can put the link in there.
we gotta
Have a bunch of people jumping in the backstage. It gets crazy.
we gotta figure out how to put a link just in a chat.
I did already.
Oh, you did?
I figured it out. I copied and pasted it. Yeah, I did it for the Zone of Death. Ashley Kane asked if I would drop a link in the chat to that story about the Zone of Death. And yeah. So see, learning. I love how y'all help me learn. I learned so much. Through all this, I've learned so many things from from tech, from just learning different platforms, learning different social media sites. It's opened my eyes to a lot of things, and it's crazy, expanding our horizons for sure.
I just learned, which I messaged you last night as soon as I figured it out. I didn't even know that I had a community wall on my YouTube channel.
You have to have 1,000 subscribers, and I think that's the thing. Once you have 1,000 subscribers, you can go live, and you have the ability to have, you have the community wall also, which I never really use it. So there's a lot of times I don't see people's community walls because I do a lot of my YouTube viewing on through my Roku device on my TV. And so it doesn't have all, the extra stuff.
See, that's exactly what happened with me. Is I don't do hardly anything with my YouTube channel from my phone, and I don't.
It's from that angle, right? Yeah.
Last night I was on my phone and just fell bass backwards onto it and seen all these stuff that I could do on my channel. I was like,
oh,
wow.
No. Yeah, so now I get it. I thought you were talking about when you say documents, I think you're talking about FOIA docs. So that's my bad. And so you're talking about like these filings, right?
Yeah, the stuff.
Somewhere you can share these filings is on your community wall. That's a perfect source, for you to be able to share with the community. That's amazing. That's good. And I'm glad that, you're able to, what is it? Allocate? I think that's the word. I don't know. I'm trying to expand my vocabulary without the F-bombs and everything. Okay. I don't know how to say that. If Kresha, she said, Kresha, you are, I guess, Kanger? Dutch. Never forget that. What is a Kanger? Or am I Dutch? I don't know. What you mean, Miss Carla? Right, Donna? Donna says, Eric, doing things back asswards is my style. Touche. You're in good company.
Yeah, Kathy, I was I was
Okay.
so excited last night when I found out I could do that. I'm still learning. I'm not sure how many actual docs it'll let me put up at one time, but yeah,
Yeah, the most I've seen is like three or four. I don't know. Delegate. That's a good word. Yeah. Oh, I shouldn't do two things at once. My mind just froze up. Okay. Let me. I'm gonna go get to Robbie. He emailed me.
okay.
I'm on my way, Robbie.
I'm right there with you, Donna. I'm back asswards all the time.
It's the only way to go. Oh, okay, come on. There you are,
Hey,
Robbie.
Jay in the Ray. What's up, KD?
Okay, Robbie. Now I gotta go fetch. Now I gotta go fetch the code. Do. Come on. I know it's second nature for a lot of other people, but it's not for me. And that's okay. It will be. I'm a work in progress. Okay, let me go to this phone. I feel like Lori with all my phones. Okay. Screen. Oh my gosh. StreamYard. Oh, I hope it don't go whoop, 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 whoop. I hope it does not start echoing.
I don't hear it.
I know. I have to enter the studio to get the link. Okay. I'm gonna mute. Okay. Oh.
What happened?
Was I muted the whole time? Okay, now you can hear me.
Yeah.
Okay.
I
I even muted my mic and it's still boop, 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 boop. Oh my God. Okay. I panicked. If y'all could just see me, I'm like, it's like fight or flight. Okay. Hold on, Robbie. I got to remember where to go fetch the damn. Okay. Invite. Ding, ding. Okay. Cheese and rice. You'd think it'd be easier than this. So that's a lot of things going on at one time. And Zoom, that one just blew my ever-loving mind. I was like, what the hell? Oh, there were too many options with Zoom. And then with StreamYard, which is the service that we're using right now, it's so easy. You're like, well, where's everything? You know, it's like it's such an easy layout, and so it looks so different than Zoom, polar opposites. So it makes me feel like, well, do I have everything I need? Weird. Okay, now I'm going. Okay. Copy. I'm on my way, Robbie. Just slow and steady wins the race, they say. I'm a firm believer. Okay. Go ahead, Eric.
I'm on Michael Monkey Vaughn's
Okay, good.
right now because I wanted to ask you if we start out with Summer Wells and Monkey Vaughn, and I have another young baby
Okay.
that I have her
Here.
information on.
Okay. Go for it.
Well, I'm gonna.
You're doing stuff too. This sucks.
I'm hoping that it'll let me put the flyers up. So just bear
Yeah,
with
me and
me.
you kind of practiced yesterday, and I just sent that to. I just sent this to. I hope I sent the right thing. To Robbie. I just noticed it put a hyphen above the E in StreamYard in the link. So if so, Robbie, please fix it. But that is the link for StreamYard. It just I don't know why I put the E like that. I like took a picture of it, and then extracted it from the. That's how hard I make things. I'm sure it's not that difficult, but that's what the hell I do. Let me copy that link to the clipboard in here, and that way we have it in here. And I'll put it. I'm putting the link. Remind me. I'm saying it out loud so you can remind me that I put the link to StreamYard in the private chat back here, per se, the breakout room. AKA.
Sam Rollo said my avatar's creepy.
It looks like a wood fire.
Should I change it?
If you want to.
I mean, let me change it. It was actually just for.
It was for fun. Yeah,
it was for a laugh.
We have morbid senses of humor here. That's how we roll. And they may not think, it does look creepy, but it is funny. It can be so many things. It's just he is so atrocious, quite frankly. Pun intended.
Okay, so I'm gonna leave the studio for just a minute, okay?
Okay.
And I'll be right back in.
All righty. Are you on your way, Robbie? I'm sorry. My voice is crackling. Come on, Robbie. Come on down. Thank you, Little Brands, for liking. That does help the algorithm. It helps the channel to grow. Oh, well, what's new? I don't know. I don't even know anymore. Hello. Yeah. So I'm sitting here with. Hold on. Can you see what I'm saying? Okay. All right. Robbie, are you ready?
Can you hear me? Hello.
How you doing?
Hi. Hey, long time no talk.
Oh, I know.
Good morning. Good morning from San Francisco, California.
All right, San Fran.
Yeah, I got a new job out here.
Really?
Ooh, yeah, but
I'm envious. I'm so envious because you can drive and chat and all that and think all at the same time. I'm so envious.
Well, I'm just gonna keep both hands on the steering wheel. You're in my ear.
Right.
To navigate my rest little bit of the way here to work and talk to you for about 5 minutes.
Awesome.
But
I'm so glad.
thanks for having me by. I hope you're doing good. Hi, chat. Hi. Yeah, girl, your content is on. It's on fleek. Your content's on fleek. I watched your video yesterday. I don't know if you got my message, but no, I think that you're totally right. It's funny how like some people like I don't know, like that are just into true crime or whatever, they're like, oh, like let me latch onto this case. There's been a couple different YouTube channels. Like one of them is a podcast, and well, they were a group of guys just covering true crime, and they were trying, I appreciated the fact that they brought light to this case. They got like a bunch of things like wrong, you know what I mean? Like, so you listen to some of these other people.
I was like, no, that's not at all how it went, but yeah, at least try to get the fact right.
Yeah.
Guys. Come on.
For real.
Read it.
So, I totally relate to you there. What else was I thinking when I watched your replay from yesterday? Oh man.
Thank you for that. Thank you for keeping up
No, absolutely.
and trying to, you do your best with me. And I know I'm
Yeah.
not I just have so much on my mind, on my plate. And so it's so
Sweetheart,
hard.
you and I are alike in so many ways. I have I mask my ADHD really well, but sometimes I don't. You know what I
Done that for
mean?
years. It sucks. It sucks.
It's hard.
Yeah, it is, because you just try to be in the norm, and yeah,
Mhm.
it's in a lot of ways you kind of dilute yourself,
Right.
and then I'm just trying to just
trying
be
to get
me.
by. Just
Right.
be me.
This is
Yeah.
me.
No, I totally
And
agree.
I'm not everybody's cup of tea, and that's okay. I'm okay
You know
with
what?
it.
That's something I've had to learn. It's just like not everybody's gonna like me, and that's just okay. You know.
Exactly.
That was my biggest thing for the longest time is that, I get so frustrated about, people taking judgment against me, but the reality of it is like not everybody is going to like you. And
It's a reflection of themselves. The things that
Right?
they pick out and hype and criticize about others are things that they are unhappy with about themselves. That's my personal
1000% couldn't agree with you more.
Yeah. Yeah. So how
Am I
have you
breaking up?
been?
Okay, good. I've been good. My new job is basically teaching or helping teach robot cars how to drive. So pretty freaking cool.
Wow. Sounds
Yeah,
fancy.
I'm pretty excited about it. And, it's actually using my degree that I went to school for. So it's like,
That's always nice.
Well, it was funny because I went to school. Yeah, right. Well, I went to school and I got this big fancy degree, and then I went back to work at AT&T, and I was like, wait a minute here. What are you doing, Robbie? You didn't go back to school to do business major-y stuff, I wanted to be a technology major. So, but yeah, no, I'm doing really good. I don't know if you've seen pictures, but I got a new puppy. He's doing great. Yeah, he's
awesome.
his name is Menelaus. Yeah, no, things are going really well.
What does that mean? What does Menelaus mean?
Menelaus is like, if you watch the movie, I was watching the movie Troy and with Brad Pitt, and King Menelaus is one of the characters, and basically he's the one whose wife gets stolen from him, and then he goes with the Trojans over to get his wife back, with the Trojan horse and everything. That was King Menelaus right there.
Okay.
So I don't know. I just liked the movie, and I was like, "Damn, Brad Pitt's fine." And
right,
like, wow, what a cool name. And we call him Manny for short. Manny.
Shot, baby.
So
I know that Robbie went to. He does a lot of camera work with the drones, using drones, and he. Go ahead and tell them what you did.
So I did go to Tammy's gravesite, and I got some shots that we can use. We got some shots that we can use. I'm gonna have to mask up because I have to start walking in. We got some shots that we can use for some videos, and I do want to do a video, like my take on like Tammy, because I really feel like she's like probably one of the ones who's silently not really represented. Hold on a second, I gotta get out of the car.
I know. I hate that, but I feel so indifferent sometimes because I don't want to overstep boundaries. However, I do want to speak for her.
Right, and it's hard.
Up.
No, and it's not even her own children, and that's what really gets me. Like,
yes,
like I went on a Hidden True Crimes chat one night, and she was talking to Lori Hellis, and they were like kind of like sympathizing a bit with the kids, because sometimes that'll happen. Like, people will be like, oh well, they're both
they never
victims.
think of
They've lost.
I know. Yeah, they leave
Charles
out.
They both lost it. Yeah, and they leave Charles out too, for sure.
I mean, not just them, everybody. Just because a lot of people pick the case up as that's when it broke. Nation news or whatever, national news, was the kids are missing, and so it was discovered that he was murdered and all that jazz. But yeah, go ahead.
It's weird. I think that maybe this might be just like a weird thought, but like, what if like what if your mom and your family was like LDS or more like on that side of things, like, because you know how like some of like Tammy's family members and stuff have just been quiet about the whole thing, and like
They have a
Chad's
different
extended family has been quiet about everything.
Yeah, I know exactly.
Like what
I
if like it's like
understand,
what
but
if
then I
Kay and
don't.
Larry were members? Would all of this would have ever come out?
Right. Everybody would just be quiet.
Or would everybody just be quiet?
That is a
You know, just something to think about. I don't know. I was like, wow, that's
that is
weird.
a
Because
good-
and then you were playing the video about that little area in Idaho / right, yeah. I think there's a little bit more there. Something weird is going on. Should be interesting to see what happens. I'm gonna jump off here. Thanks for letting me jump on and like consume like the entire conversation.
I
Love
We
you.
love you. Thank you.
Yes, let's
Have
catch
a
up
good
soon,
day.
okay? All right, bye. See you guys.
Bye. Oh, let me get back to the chat. Oh, that was good. Thank you, Robbie. I don't know if I've ever. Do I have to? Bo Peep. I'm answering Bo Peep's question. And she's asking Kathy if she knows how to put the links, but I've never provided them to Kathy. So she's probably, that it takes communication, and that's something that I have just had a hard time in the grand scope of things. Even though I know if I just hurry up and do it and get it over with, I don't know what I need to do. I try to, like, I do have things saved in the background here, per se, backstage, if you will. And like, I can do this, like the hearing begins at 9 Mountain Standard Time. And then I have that. And then like I put that, it's just Robbie. He was here. And this. So there's things that I have back here. I just need to remember. But yeah, to drop them in the chat. Kathy, I'll call you or text you, or you know what I mean. I'll send the info to you. That way you can have these things. Because that would help, right? Help me help myself. If you, yeah. Yeah, I have. And that's, okay, the banner right now is for Venmo. Let's see, Love Always Wins. And then for the bracelets or whatever. I'm trying to read it as it goes across. And I don't know if I have that worded right, because anyways, it's HTTPS. I guess that's a semicolon / I don't know how to say all this computer talk. That's where I just feel silly. So, and like the Let's Restore. Lordy ho. It rhymes with core whore. Lore whore. I'm so glad Robbie came. That was good. That was really good. And he really did some, I don't remember if it was a YouTube channel. I think he has a Twitch. I know it was Twitch. It was a Twitch account, because that's the only reason I ever got Twitch. I think that's the name of it, Twitch. If I'm saying it wrong, let me know. But anyways, I went and checked out the couple of videos with the drone footage that he made of Tammy, the graveyard, the gravesite. And it was really, 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 it just impacts you. And he also did one on my Uncle Charles, because not many people remember him also in this. Just like Joe seems to be forgotten. And I don't know how we're going to get justice for Joe. I just kind of, in my mind, I just kind of lump them all together, because I don't even know if Lori will ever have to go to Arizona at this rate to, answer to the murdering of my uncle. And so I just kind of lump them all together. It's Joe, Brandon, Tammy, and the kids, Tylee and JJ, and so those 5 are together in my mind, my heart, my platform, their platform. It's theirs. And it is to amplify their voices that were snuffed out. And I like using that word because that's exactly what they did. Oh, hi, person of interest. I never chat, but I like popping in here. Thank you, Cresho. We'll follow you till justice comes. You're doing so great. Love from South Africa. Oh, that is so far and so awesome, because that just is proof right there. Person of interest is in South Africa, and we're being heard. This platform's being heard, which means Tylee, JJ, Tammy, Charles, and Joe's voices are being heard, right? There it is. And that's what's awesome, I think. Okay, and Eric is back. Hello.
Hello.
Welcome to the family. No. Welcome to my channel. I don't know how many times I've heard other, just listening to other videos or whatever on YouTube. Welcome to my channel. Oh my God, I would feel so silly if I were talking to do the pre-recorded video thing. I'm Krishna. It feels so weird talking to something that's not talking back to me. I've always had a problem with it. And my daughter used to FaceTime me, and I'd be like, boop, I turn it to the ceiling, because I just don't always like to be put on the spot, I guess. I don't know. I know I'm not the only one like that.
No, not at all.
Like when somebody knocks on my door unannounced, I'm like, the Matrix. I'm like, quiet, like, no. Do not just be showing up. I don't know. I've always been like that. So I wasn't mentally prepared for you. I guess that's a good way. I'm so glad that Robbie was able to come on. And that is it.
Yeah, I was going to ask you that.
Go ahead.
I was going to ask you that because I'm actually trying to get these flipping Google slides uploaded, and
okay, all right.
It's not.
I think you do have that fan though blowing across the sound. It sounds like you're in Idaho where it's really windy. like my dad Larry, he's like, I went to Kansas one time just on a business trip, just to go pick up a truck and come back. And he said the only thing stopping the wind over there is a clothesline. I was like, him and his little adages and his old sayings. I love it. I love Larry. Oh God, I was so blessed. I am so blessed to have such an amazing, and I hate even saying stepfather, so I'm gonna say bonus father. So he's just been a wonderful blessing in our lives for over 20 years, and I love him. I don't say it enough, so I guess I'm just taking time right now.
Never a bad time to say that.
I want him to know that I love him, and not just here, I need to make a little more time and go visit in person, I think I'm having some introspect right now, guys. I'm running. I'm actually feeling emotions and working through them as I'm speaking right now.
You guys live a pretty fair piece apart, don't you?
No, not anymore. They moved again. I mean, they had moved because there was quite a bit of damage to their home from Hurricane Laura. And that's another thing, y'all. My hometown, Lake Charles, was obliterated. It was just, I swear, had it not just changed trajectory just a little, we would have had a 20-foot surge wall And I didn't even realize what that entailed until we were evacuated. We went from Lake Charles to Lafayette, which is just a little bit east of here. Like 70 miles, I guess. So not far, but enough, to not be hit with the initial impact, because we're only like 30 minutes from the Gulf of Mexico.
You missed the eye of it.
And so, yeah, the eye shifted and went east just a little bit. And I mean, the eye wall ran through Lake Charles, and always the east side of the storm is the worst side, I had to think. And so, anyways, so that's the only thing that saved my town. And I mean, it's a city. From being totally just like New Orleans, their thing was the with Katrina. Oh, I just forgot the name of the thing. The levees broke. It's crazy. And I know where I live. And people are like, well, then don't live there. You have a choice of whether to live there or not. Hey, Judy, electronic medium. Oh, I got to get back to you. Just let you know, I saw it. I just need to get back to you. But yeah, with the hurricanes. And so Lake Charles, it's like it was during, coronavirus. Everything was just chaotic with the cases and everything. And it was just for me, and like me and Mom shared with each other, that it was a distraction. It just like for a little, I just want to help. And I just want to share this insight with you guys. From our perspective, a category 4, it was really a category 5, but I think for insurance purposes, they're going with a 4. Wink, wink. That way they don't have to pay claims. And so there's a lot of people that are homeless here now. And people have come in and they are helping our community. Our community is helping each other. That's what we do here. And it sucks because it just wasn't like FEMA. They did nothing. Nothing. It's like we've been forgotten here. And I'm speaking for my community, Lake Charles, Louisiana. We got hit with Hurricane Laura. Then we had a tropical storm. And then 6 weeks later, we had Hurricane Delta, which was another category 4/5. And we just got nailed from the south. And then we had Lori from the north, all sides, So, yeah, that's a long story of telling you that they moved. So I apologize. But I'm glad you reminded me. So, but it's nice to see you, Judy. Judy is, she has a channel. It's Electronic Medium. And I discovered her through these cases, this story. I know a lot of people frown upon it, and that's fine, to each their own. But when you are actively looking for answers of your family, these 2 children that are related to you are missing, and you will do anything to just know where they're at. You'll do anything. I'm telling you. It makes me want to cry. And you look to, I think that all forms of research are interesting. They all give you some kind of interest, I can't talk today, perspective. You don't have to take it literal, but I heard, she does things with, what do you call it? Like in her name, electronic medium. It's like, I don't know how to talk about it. Just go check her out. But she did some videos And I heard my uncle's voice, and I heard Tylee's voice, and they were trying to, say where they were at. It's really crazy, and it's really, really cool. It's just another way of looking for answers, another way of investigating. And I find it helpful. That's me. But anyways,
That's all that matters.
well, I mean, a lot of people, they're like, oh, and she's not a psychic, she's not a medium. That's just the name of her channel. She's intuitive. And I think she's got that gift a little more than she even is aware of. But it's a science, it's science. You just kind of want to, like I said, you'll do anything if it's your child or your nephew and your cousin, Tylee and JJ, they were missing. I would do anything. I wanted answers. And so I just kind of, like I say, I cherry pick from everywhere. And it just helps me to form a better picture. Anyways. And also, Carla, thank you. It's also healing. There's one she did on Tammy, y'all. And Tammy says, Enoch, my awful, awful son. And I'm going to leave that right there. And then I'm going to tie in where Enoch comes into play in this. Not right now. That's video form. That's got to be a story that's told. And it deserves, like I said, the multiple mortal probation issue. The multiple mortal MMP. It plays as a map. Like I said, it's the means in which the method that they used to justify, in their minds, to justify murder. I find that says so much, right? And so not everybody is interested in that. Not everybody thinks like that. I do. Because we want to know why. Why? Well, I also want to know what was the reason. What made them think that this is justified? What brings one there, And so when we go into looking at the minds of killers, this helps give a lot of insight, in my opinion. So that's all the work I've been doing, along with everything else. It can't be brought to court. No, but it is the plot. It is the script. I don't know. I need to look up in the thesaurus of all the other words that, synonym with that. So, anyways, but
Don't ever.
Is it about?
Don't ever apologize
Whoa.
for what you're doing.
Wait, what?
Don't ever apologize for what you're doing.
Okay, your voice is like, it's weird.
I said, don't ever apologize for what you're doing.
Okay, I hear you, but I think there's some issues with the sound. Like I heard what you said, but it didn't sound very good.
Okay, what about now?
Mm-mm.
Okay.
Okay, there.
How about now?
Beautiful. Oh. Yeah.
I had too many windows opened up again. I'm trying to get these missing posters uploaded, and
it's okay.
I can't figure it out. So
we also have after, we can talk after the hearing as well, and that way we can use this platform also to shine light on some other stories, other missing persons. We've got to learn how to work it into it.
So frustrating.
Yeah, he did sound like Darth Vader for a second. That's what perfect. Perfect. Oh,
where did Robbie go?
Who?
Robbie.
Oh, he was on his way into work, and so he just slid in like Robbie does. He's just
Popped in.
yeah. Like I said, I told him like I'm jealous. He's so good at just multitasking. He was driving, backing up. I couldn't. I would be like, oh goodness.
Hello from Glasgow, Scotland. Hello, Celtic girl.
Hey, oh my gosh, that reminds me of my parents used to own a transportation company. They owned buses, which how many times do we hear Chad's gonna throw a lorry under the bus, under the bus, under the bus, under the bus, under all you hear is buses, okay? And I'm like, Mom, Dad, Larry, put insurance back on the 2 buses and let's literally drive them up to Rexburg or wherever this damn court hearing the trial is gonna take place and just be the bus. Just let's be the bus. And then Mom's like, hell no, the insurance is way too high. That's how my mom thinks. She's very frugal. She is. That's admirable also. You're from North Texas, but I've lived in South Louisiana. So I know how devastating hurricane season can be. If they say stay home, you stay home. Yep.
But the thing is,
you get enough time to go. That's what I'm okay with. It's like, okay, well, you have at least a week to kind of, okay, well, there's one entering the Gulf to, oh crap, like what happened in my case. I was so wrapped up in this case. This is what, June of 2020. Sorry, I have the Valo curse. Anyways, Uncle Charles did it really bad. But anyways, and so Mom called me and she was like, hey, are y'all evacuating? And I was like, for what? She was like, get your ass. and I was like, whoa, I didn't even know there was a Category 5 hurricane coming right for us and a day out. It was only a day out. So we did just that. We hurried up and packed our asses and we hauled ass to Lafayette and had to stay there for quite a while. We were blessed in that sense. We have family. My Uncle Bobby, y'all heard him in this FOIA drop when he called the detective and talked to the detective.
Mm-hmm. Yeah, that was, I remember, and I know everybody else does too. I was so salty at that detective in the beginning of that interview because he came across as, real smart assy.
The cop, I know. I was like, you are being a total DICK.
Yeah, right. Yeah.
He was not at all empathetic or nothing, sympathetic, nothing. It was just like, you're getting on my nerves. Why you're taking up my time.
Yeah.
Again, just like with Charles and the police, it's like he was just bothering them.
Yeah.
It depends on how you look at it. And so,
and I know daggone good and well that you and your family, Cheryl, and the boys,
Zach and Cole, my uncles, Uncle Jerry, Uncle Bobby, my Aunt Susan, my Aunt Terry, my mom.
Right, but the only one that I officially seen in the docs as being on record as reaching out to that detective was your uncle, Kay, Larry, Cheryl, and one of the boys. And I'm sorry, I forget which one it was.
It's Cole. He's the older brother. He's Uncle older son.
It's not like
they're
there was 1,000. Well, it's not like that detective was getting slammed by 500 people a day.
Right.
He was just he eventually chilled out toward the end of it, but when it first started, I wasn't a happy camper, which I don't matter, but I was fired up.
Yeah. And I mean, when all that came out, basically when Mom and Larry are on the phone with that detective, that's about the time, you know how I reference and say, hurry up and get to Arizona before she burns him. Before she cremates him is what I meant. But, you know, I was like, before she burns his ass, you know, and this is way back when. And you look back and you're like, man, she did just that. She burned him. And so in more ways than one. So anyways, that's just weird. It's weird that hindsight is 2020, or as Tylee said, in retrospect. I love how she says that, in retrospect. Poor baby girl. Again, I do notice that there's a lot of division that happens from time to time. And I don't know why. I don't understand it. I believe that Tylee had it bad. I believe JJ had it bad. I believe Charles had it bad. Tammy had it bad. Joseph had it bad. They all, I would say they didn't win. Right? So I don't do the, you know, empathizing or sympathizing with one over the other. They're all victims, and they're all equally victims.
Right.
That's what Lori did. Lori caused division. She caused animosity, and she did that. That's what she did. That's how she controlled and dictated everything and manipulated everybody to her narrative. That is what a narcissist does. They destroy, they divide, they cause all this friction, and then they manipulate and play everybody like puppets. And so it's just weird. But just some people are like, you know, oh, JJ, just like Tylee says, well, Charles is so horrible to Tylee, you know, but he wouldn't do that to JJ. She's just so proud to say that. So when I see it done here in this community, I'm like, ew, I'm disturbed by that. That disturbs me. And I mean, I understand what the person is saying. And I get it, but I don't do the division of the victims. They're all in the same. Nobody won. Nobody wins. Nobody wins in that. Nobody was a favorite, is what I'm saying, of Lori's. So I don't want that ever expressed here, please.
Cresha, there's a couple people wanting to come in and chat.
Okay, I'm sorry.
Mikkel Waddle and Liz Johnson.
Liz, let's see. Okay, let me get back to banners. That's where I was. Hold on, and that way I can put the email address, Cresha0123@gmail.com. Just let me know, and I'll let me go check my email.
And Pops, I did not know that about the number of cases that just went south in Arizona, but I am well aware of Miss Adele and her can't pull away from the bottle long enough to come to work and do her job. And
Where?
Arizona, the DA from Maricopa County.
Is that the
Pops,
one that was drunk?
Yeah. Pops just said that, hang on, I'll find it.
I have been mapping out Arizona. I've been just kind of figuring out the politicking situation, because that's what it all is, in my opinion. It is now politics.
It said 1,200 cases have been dropped in Maricopa County from 2020, because of the DA misconduct. Okay, well, I may have read that wrong, because I don't know if this DA was in office or not in 2020. She could have been, but this DA, Alistair Adele, they put out a letter. Her colleagues put out a letter because she had slipped off the bus, not showing up to work, and they just felt like she wasn't doing her job. But now I don't know if the DA in 2020 is this same person, so I'll have to check that out after.
Liz, if Liz, Mikhail I just got an email from Mikhail, and so I dropped the link to her. Liz, if you'll email me at cresha0123@gmail.com, I'll drop the link for you too. And just keep refreshing it.
You should just put your email when you're
doing that. Right there.
And put it on the ticker, though.
It is. It's on the screen right now.
Yeah, I mean, it is, but what I'm saying.
Oh, like in the chat?
Like, because when you want to highlight somebody's message or whatever, see what
oh,
it
okay.
Covers up the email.
That makes sense. I got I hit the wrong thing. I always do that. And I'm trying to hide the thing that's going across the banner. That I keep that's what I come in here to keep doing, and then I don't do it. I'm so sorry for the
It's fine.
Well, I mean, I'm apologizing to Chad. Like anybody who follow just regular content, regular creators. We're not regular here. I'm not regular. Like, this is me trying to cope and deal with my family. These are my relatives. And I'm a co-victim. I hate saying that, but I don't know how else to say it. Because they're the victims. What did I come in here to do?
Mikhail said it's not allowing her to join the chat.
All right. Is there any way you can go into the banners and hide? Never mind. Let me hide it. There. Finally. Whew. Got that done. I don't know. I'm trying to figure it out. It worked for Robbie. Oh, I'm just going to drop the damn thing in the chat. Just everybody don't be like, I can only handle one per call, because it gets really, really confusing. All right. So I put that in private chat. Let me go grab that real quick. Copy. And I'm going to drop it into the chat. And paste. And I just know that it's 10:15 here Central Standard Time. So we have 15 minutes until showtime, right?
Right.
9:30 court starts. So please keep that in mind, Mikhail, when you come on, that we can, it's brief, at least for now until it's over. And then we can kind of be a little more relaxed.
Kathy said that it was the same person in 2020. So if that's the case, I think that
what are you talking about?
Arizona.
Okay.
And I believe Kathy, I'm not saying that I don't, they need to refile everything since that lady has been in office, because
that's not fair.
I told Gigi last night, I think it was, that put the case in front of a trial and let the jury decide whether or not, if it's able to be convicted or not. Don't turn down cases just because you think you can't win. I have a problem with that.
Hey, Mikhail.
Hey, Mikhail.
Hey, y'all.
How you doing, baby girl?
I'm doing great.
Good. It's so good to see you again. This
I
is
lost
Mikkel.
my mama, who had been staying with since Christmas,
I'm so sorry.
a month ago. So I've taken that hard, but I'm glad to be back.
Well, I'm glad you're here, and I'm sorry for your loss. And continue. That I just know that my heart goes out to you. Our hearts
Thank
go out.
you.
You have us. We've had you, and so you have us.
Thank y'all.
It's gonna be okay. It's not always easy. It's not easy at all, but I don't think it gets easier. I just think we get better at
Coping.
Yeah. So you're not alone. And
Thank you.
I gotta put Miss KJ in the radio. Hello, KJ.
Good morning.
Hi,
Morning.
KJ.
I'm still waiting on them gravy and biscuits.
Well, they were out of gravy, and those biscuits that I served. Listen,
Cold.
they look like the ones that we served to the inmates when I worked at the prison.
Yay! Good.
I wasn't real happy with the biscuits that I had to put out.
No flaky layers or anything.
Oh,
Just small, real small, solid rocks.
Cat head biscuits.
Sorry, y'all. I'm trying to read in the chat. Y'all know how I am.
Hey, I just the reason I apologize, Kresha, I probably should have okayed it before entering backstage on there, but there's just something I got to get out here. I just don't understand how they could tiptoe around talking about Lori in today's severance hearing.
I agree with you.
I mean, we're not asking for her protected stuff. We just
We
want
don't
to
want to know the deets. We just want to know. They tell us everything else, right? I saw your comment earlier where you said that they tell us that she's going to. How'd you word it? I don't want to speak for you.
Well, they didn't have a problem letting us know she was put in there.
Right.
They didn't have a problem telling us they extended the 90 days to 180 days.
Ordering her to take her medicine, right?
Yeah, there was talk about her talking. They didn't have a problem letting us know about Utah. Now, I think Mark Means had something to do with that.
Yeah.
And that's one of the reasons he's off the case now, I do believe. But I'm just saying, John Pryor cannot argue just prejudice. He can't just say, well, this will prejudice my client. He has to bring in the fact that she's still in the mental hospital or something. It can't, because they've already visited that whole idea at the beginning when they wanted to join the cases. The judge said, no, I don't see any undue prejudice. So why he wants to argue that again, I guess he's got to do what he's got to do. But without talking about Lori and what her status is now, I don't know how. And yes, this could be something about the breakout rooms, but it's still BS.
Patience, KJ. Breathe.
Well, I'm angry about it.
It's okay to be angry. It's okay. Sure.
I'm just saying.
Good morning, KJ.
A judicial process should have as much transparency to the public as possible. And it just seems like they've done half of the stuff in this whole case behind closed doors. And we're not talking about protected HIPAA either. We're talking about they're doing things that just don't look right to me.
They aren't transparent. Transparency is imperative. Like it is key. In my opinion, that's how everything should be. If we had more transparency across the board with everything, then we wouldn't have as much evil shit going on.
I agree with that, Kresha.
There's nothing wrong with demanding that. There's nothing wrong with pointing that out.
But you have to remember that it's Idaho, and the two. Well, I'm just giving an example.
I know, but I don't.
Look at what Arizona did with their FOIA, and look at what Idaho has done with their FOIA. We got everything before the case even. It doesn't even have a docket number in Arizona yet, and we've got the whole case file.
Oh wow.
Yeah, well, there's a trial
People
coming
filling in
up
the
in
blanks and
Idaho,
stuff,
and they're
that
not going to
bothers me.
release a lot of that stuff. But in
Right.
Arizona, they knew they weren't going to do anything, so they just released it all.
Not all of it though.
Yeah, the case against Lori, conspiracy to commit murder on Charles Vallow,
Yeah, I feel
they're
like
going to
there's
hold that
more.
stuff to their vest.
There was something else I thought of. I was like, well, I didn't see that in the FOIA dumps.
No, the Chandler dock dump is
FOIA.
Lori and Charles. We got the full case dock dump for Charles's case. They
We
have
do, but do they?
left to put out. Now, with Brandon's case, which is in Gilbert,
Which is ongoing.
We got just a couple smaller ones. But it's going to get thrown out. There's nobody going to be charged for that. There's nobody going to be charged for that.
I'll be right back.
And I'm angry with you, KJ. I hope I didn't come across that way, but it's just they're Rob and Lindsay, they're just making sure to use their words, an abundance of caution to make sure that they get this right.
Well, when you've already got one attorney thrown off the case, you've also got other, I mean, you think about everything within this whole case. You think about them trying to get Rob Wood taken off. Then you look at John Pryor wanting to look into the background of Rachel Smith. Then you want him filing a motion to get Rob Wood taken off again. I mean, this is littered with all kinds of just crazy stuff that doesn't even need to be in there.
Right. And he said yesterday that he's not pursuing those two motions. He's not going to be arguing to have Rob and Rachel removed.
Well, then why did he put them out there in the first place?
Well, because
explain that. Just give me a good theory. Give me a good theory why he would even go there. That looks like a Mark Means move.
Well, I mean, it is. It's a typical defense attorney move. Throw everything at the wall and hope that something sticks. And I mean, that's not even a theory. I can't tell you right now of any person that I've ever heard of a case being dismissed over a grand jury or over anything else. I mean, it's just the motion to dismiss, and I said this a month ago to somebody, all it is a noise motion. That's all it is. It's a noise motion.
It's basically John Pryor standing up in Chad's preliminary hearing to say, don't bind this over for trial. It's just the same argument.
Right. But now, Pryor has much more discovery, the grand jury transcript, and I forget off the top of my head whatever else he has, but yeah, I mean, one of them is he's asking to dismiss the case because they were unable to seat an impartial jury for the grand jury. So, it's just throwing bananas at the dartboard and trying to make it work. I mean, it's
yeah, let me just make this comment. Language of Horses says, hi, everyone. I promise not to get angry or negative about whatever happened. Yesterday, I was a jerk and I'm sorry. Well, Language of Horses,
I'm a jerk.
I have not been myself. Many of y'all can figure that one out. I haven't been myself since last week because there is no reason whatsoever that on a general basis they should not be telling the public what status Lori's in other than inactive status pending.
But
But what, Big E? The bottom line is they let us all in on everything else, and now they're going to stay silent. They're not going to tell us anything.
just
Okay, I'm back.
just hang on just a little while longer.
I'm refreshing back here.
I know it's frustrating, but
I have to look up to y'all for being so level-headed about it. I guess this
We're
is
trying.
where
It's
the
ongoing
true
battle.
nature of just being a human being and being who I am. I see things just a little bit differently. I guess maybe I'm just impatient. Maybe I'm just angry because these victims have not gotten their justice yet. I mean, just the laundry list of things that I see that's gone on in this adjudication process that really bothers me. And maybe it's out of my own ignorance, but I just see what I see.
no, it's not.
Okay to
It's
express
not.
that.
It doesn't have anything to do with
I appreciate your perspective. I appreciate you expressing, what a lot of people here want to express, and a lot of people are feeling. I've got to go. Jason is snoring, y'all. I got to go roll him over again.
Actually, it's 11:29 too.
I know. I'm watching that. That's what I've been doing too.
Oh, okay. I'm sorry.
Oh no, this is
Wow.
a horrible setup. Oh my goodness. Okay,
I think you've done great, Cresha. I'll be listening on the hearing, and if you want to get with me after that or whatever, I'm around. Big E, love you, man. Thanks for always staying level-headed, positive, and always wanting to do the right thing. And I'm looking forward to Big E presenting some of these missing children as well. So anyway, I love all y'all. I love everyone on this line. Y'all been good to me. Y'all been patient with me, and I love y'all. I'll see y'all after a while.
Thank you. Eric, you're gonna have to talk. I gotta go. I gotta mute myself real quick and refresh, please.
Okay, I'm on it. And I know what KJ is saying, and God knows I've been right where she is and where everybody is, but everybody just hang on. That's just hang on for just a little bit longer.
Yeah, we'll keep on keeping on. Can y'all hear me now? Yeah. Okay.
Yeah.
Oh goodness, I had to go roll him over like 3 times. I was like, dude, you're snoring. Everybody else has YouTube studios, and I'm like over here in a corner of my bedroom. It's crazy. Crazy, crazy. Crazy is all I got. Amen. Let's see. Why is it echoing? I'm trying to figure that out. Okay. I'm just refreshing back here, guys. Were y'all able to hear it really well yesterday?
It was fine to me. I could hear it fine.
Good. You'll have the cool sound effects, okie dokie. Well, good, because we got them. We got them around here.
This
I'm
is
smoking a cigarette right now, too, so that's why I'm off screen.
This is the first time that Judge Boyce has actually left a hearing up on his channel.
Right?
I wonder
Yep,
why
I
that
know.
happened.
I don't know. He probably they forgot. They're too busy, covering everything else. When you have to, keep everything secret, it begins to be a little difficult.
I know.
Touching all the bases. And I'm not impugning anything. I'm just saying it gets to be a big thing to keep up with. Kind of like a lie, a lie is the same.
And Oh, he's live.
Okay. Where? Okay.
Chad Daybell is in the hearing.
Gross. All right, guys, we're gonna hide.
I don't have any audio.
I don't either.
All right, good morning, everyone. This is KCR 22-211623, State versus Chad. Guy Daybell. Mr. Daybell is present, represented by his attorney, John Pryor. The state is also present, too, with prosecutors. Ms. Lindsay Blake will be arguing, I understand, on behalf of the state at the hearing today. This matter is being recorded on the court's FTR system, as well as this Zoom hearing. We're conducting it remotely. It's also being live streamed on the court's YouTube channel for public access to this hearing. At this time, then, the court has scheduled for this morning a motion to sever. The motion to sever was filed on the 9th of September 2021. Thereafter, a brief in support of the motion to sever was filed on February 9th. The state filed a brief in objection and opposition on February 24th of this year. The court would note that on May 25th, 2021, in this case, a single indictment was filed in the case, which included charges against both Mr. Daybell and also Lori Noreen Vallow, including multiple counts that have conspiracy charges. And so the court has previously gone through and ruled that the cases are joined pursuant to Rule 8B of the Idaho Criminal Rules. And so this motion for severance was made with the defense request that the case or the defendants be severed. So at this time, Mr. Pryor, are you ready to present argument in support of your motion?
Yes, Your Honor.
Okay, you can proceed with your argument.
Thank you, Your Honor. Judge, in this particular case, the two cases, as the court pointed out, were joined by this court. Subsequent to that, there was an order that put a stay on Miss Lori Noreen Vallow's case. I am not afforded the opportunity to get any information about the status of the Lori Noreen Vallow Daybell matter, and I don't have information as to what her status is. However, I do know that the stay is still in place, and I've not yet seen a transport order that would transport Miss Vallow Daybell back to Madison or Fremont County. I can only presume at this point, Judge, that there is still a stay and that there hasn't been any determination by this court as to what's going to happen in her case. The reason that's concerning, Judge, is that we do have a trial that is set for January. I think it's January 9th of next year, and it's fast approaching. There's a significant amount of preparation that needs to be done, and that preparation is going to include whether or not the cases are severed or whether they're joined together. And I'm not going to get into tactics, but I can assure the court that there is going to be a significant difference between how I prepare in the event the cases are joined as opposed to whether they're separate. In addition, Judge, I noticed that Ms. Blake in her response said that the only issue is Miss Lori Noreen Vallow's mental state. If you look at my pleadings and you look at my motion, Judge, I also made note of the fact that there are some additional charges that arise out of Arizona. Those are charges that Mr. Daybell, at least if I believe what the press is saying and the prosecutor, Mr. Daybell has is not being considered for prosecution in either of those cases, although Miss Lori Noreen Vallow is. My concern is that there's a lot of evidence, Judge, and with this court putting the limitation on my ability to discuss specific facts as to what facts I want to rely on to say this is why it needs to be severed, I put in a blank way, Judge. I said, Judge, I'd like the prosecutor, and under the rule, be required to provide their exhibits that they intend to use and allow the court, if the court needs that, to make an evaluation as to whether there is a a significant conflict and whether or not it would have some sort of prejudice in either side, be either Mr. Vallow or Mr. Daybell presenting their case.
Right.
So it's not
on that point, the rule doesn't indicate anything about exhibits. The rule is pretty narrow in scope of what may be provided in support of a relief for prejudicial joinder under Rule 14, and that's whether or not there are any statements or confessions. It's narrowed in scope to that, is the way I read it, and I think the way the case law interprets it.
And it is, Judge, and the rule says the court may. It doesn't require the court to turn over the statements, but I guess the word exhibits, I guess I intended to mean in terms of statements or confessions or items of that type of matter. So my motion.
I guess on that point there, then the state has indicated that you've been provided most of or all of the discovery at this point, and I guess getting right to that issue then, if there are any particular statements or confessions that are involved in this case, I would think those would be something the court would consider, but I've not received any notice of any of that.
Okay, and Judge, I guess I would refer the court to the rule, and the rule doesn't say provided to defense counsel. That's correct. I've been provided the majority of the discovery. There are some issues as it relates to that, but the rule says that the court may request that those statements be provided to the court. It does not say it's provided to defense counsel. It says provided to the court for the court to make a determination. So the rule does allow the court to require the prosecutor to turn over those statements. But Judge, the issue still primarily is the issue of the mental capacity of Ms. Vallow. So given that, Judge, I'll defer to Ms. Blake and allow her to make her argument.
All right, thank you, Mr. Pryor. Ms. Blake, argument from the state, please.
Thank you, Your Honor. And I think to start off with, what the state would indicate is we do recognize that we are arguing the motion to sever today that was filed by Mr. Daybell. However, the state is requesting that the court reserve ruling on this matter until more information is available to the court and the parties regarding the stay in the co-defendant's case, which these are one case for trial. So when I say the co-defendant's case, I'm simply referring to Miss Lori Vallow Daybell's case, which is Fremont County case number CR 22-21-1624, and it is the companion case for trial. It is the state's position that it would be most appropriate in the interest of judicial economy and to preserve all rights of the parties that Ms. Vallow Daybell also be allowed to be heard regarding a motion to sever, since this also affects her trial rights. That being said, we are not asking for an indefinite delay on any ruling from the hearing today, but we feel that any information that may be available to the court and the parties, hopefully fairly quickly, would be useful in making a decision regarding the severance and also wouldn't infringe upon the rights of either of the defendants in this matter.
Okay.
So
let me address that point then. So regardless of her status of competency or not, I assume that hasn't changed the evidence you've got in the case. And I guess the issue here is whether or not there are statements or confessions which you think the court should review in order to make a determination under the rule. And I do agree with Mr. Pryor. The rule pretty clearly states that if that's going to be ordered, that it's ordered that the attorney for the state deliver to the court that information. And of course, that's not something that would need to necessarily be disclosed here in public, and we could have a sidebar, but I do want to know whether or not there are statements or confessions that need to be considered in making the determination, and not learn that at the time those are coming up at trial. So in your evidence, do you believe there are any of these statements or confessions which go to the Bruton issue and many other issues which require me to weigh that out to make a decision?
Your Honor, the state does not believe that there are any statements. We do not have any statements that we intend to use at this time that would fall under the Bruton rule as the state understands it and has reviewed the case law. As the state indicated in our brief, we have provided voluminous discovery to Mr. Pryor. We've provided everything within the state's possession at this time. Of course, discovery can be an ongoing process, and this could change at some point, but at the current at the current time, there are no Bruton issues. There are no statements that the state intends to introduce which would trigger a Bruton issue. And so what the state had pointed out in our brief is, while we recognize that Rule 14 can place that burden on the state, I don't think there's been any indication by the defense or a real issue raised with regard to them believing, the defense believing, that there are Bruton issues in this case or any statements, and they have access to the statements that we have access to. So from the state's perspective, no, there are none, and the defense already has the statements that the court has in our possession. When we look at the cases that delve into that Bruton issue, again, indicate at this time, we do not have any custodial statements. So at no time after the parties were Mirandized do we have any incriminating statements one way or the other, which we would intend to use. At this point in time, well, we wouldn't intend to use them because they simply don't exist at this juncture. And again, of course, that could change. It's always an evolving issue, which is part of the reason the state thinks it may be beneficial to preserve the ruling on severance, since a motion to sever can be raised anytime before trial. And as this case evolves, we recognize that it could go one way or the other. In addition to, if the court is inclined to make a ruling at a sooner period of time than the co-defendant, Ms. Daybell's case, can move forward, we think it would be appropriate for any ruling to be made without prejudice to allow the parties to re-raise the issue. Ms. Daybell may or may not want to raise the issue, and depending on where her case heads, the state may or may not feel that it is necessary to re-raise the issue, or depending on the outcome, if there is more information gained down the road, Mr. Daybell may want to re-raise the issue, depending on the ruling of this court. So we would be requesting that just at the outset. And I don't know if the court wants to hear the argument regarding the severance itself, or if we were just addressing whether or not the statements needed to be turned over.
Yeah, I interjected with that issue, but I would like to hear the remainder of your argument on the severance motion.
Thank you, Your Honor. And the state did file quite a lengthy brief in this case, and so I don't want to belabor those points too much. But the state's position in this case is, the first thing that we start with is under the Rule 8, and this court has already indicated these were joined under Rule 8B. It's the state's position that these were properly joined. I think this court, in its August 6th order and at subsequent hearings, has made indication that the joinder in this case under Rule 8B, when we're dealing with the co-defendants, was permissible. If it's been determined that under Rule 8B a joint trial is permissible, a defendant can always raise a severance under Rule 14, arguing that the joint trial would be prejudicial. And that appears to be what the defendant is arguing today. However, case law makes very clear, and looking specifically at State v. Gamble, 146 Idaho 331, it states the defendant has the burden of showing such prejudice. When we delve further into the case law, and the federal courts seem to deal with this issue more so than the state court, at least the Idaho State Court, the Supreme Court has also addressed it. And in United States v. Fair, in United States v. Contreras, that is not the right citation. I apologize, Judge. As the federal cases go through this, though, I would indicate that Federal Rule 14 is worded very similar to the Idaho rule, providing that the court may order separate trials of counts or sever the defendant's trials or provide other relief that justice requires if there is prejudice. In Richardson v. Marsh, 481 U.S. 200, the United States Supreme Court has found that joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. That joint trials also enable a more accurate assessment of relative culpability, advantages which sometimes operate to the defendant's benefit. And in addition, joint trials avoid prosecutors bringing separate proceedings, presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. The defendant The Ninth Circuit Court of Appeals has stated the defendant bears the heavy burden of demonstrating that the joint trial was so manifestly prejudicial as to require the trial judge to exercise his discretion on the motion to sever in just one way, by ordering a separate trial. And as we continue to go through the case law continues in both the Ninth Circuit, the federal courts in general, the United States Supreme Court, and the Idaho courts continually indicate that the burden is on the defendant, that it is a significant burden, and especially when we're dealing with cases of conspiracy. In cases of conspiracy, joinder is favored. The reason being, again, for judicial economy, we are dealing with a lot of the same witnesses, the same evidence, and there is overlap. The courts have even found that joinder is favored so strongly that even if at the end of the day, the charge itself that would require the joinder, so such as a conspiracy charge, even if a defendant is not found guilty of that, it does not make the joinder improper or a court's decision not to sever suspect in that particular situation. I think Mr. Pryor had indicated that the state raised that the only issue dealt with Miss Daybell's mental health. That issue wasn't actually raised by the state. Where the burden is on the defendant, the state has simply responded to the brief and to what appeared to be the arguments that would be made by the defense today. In the brief, there were no specific issues outlined in defendant's brief. It appeared that there were some things alluded to. One of those appeared to be the stay in Miss Daybell's case. It is the state's position that it is inappropriate to consider the stay in her case as a reason to sever at this juncture. Again, these cases have been on separate tracks, so Mr. Daybell has had the opportunity to be heard and to file motions, while Miss Daybell at times has not had that opportunity yet to be heard on some of those motions, which is part of the state's rationale for asking that any decision in this case be reserved. But regardless, we believe that until a decision on the stay in her case is made, it would be premature to factor that into a decision to sever the cases. And when we look at some of the cases in the federal system, they deal with this issue and they talk about, I was trying to get to the exact case, but it's in our brief, and they do talk about the stay in the case being attributed to all the co-defendants potentially and accounting against their speedy trial clock in the federal system, which is calculated different. But the courts go on to talk about under the United States Constitution that can be a factor, but that it is not necessarily a violation of a defendant's right to continue their trial in order to have a joint trial with a co-defendant. And it would be the state's position in this case, and I think we've raised this before, but with regard to any speedy trial issue and the right to speedy trial of a defendant, Mr. Daybell, expressly waived his right to a speedy trial. He filed a signed written waiver of speedy trial. And in Idaho, the courts have found that once a waiver of speedy trial occurs, that issue cannot be raised down the road as an issue for a delay in a trial or a reason why the trial hasn't been held faster. And I did find the case that I was referencing. So United States v. Vasquez, which is 918 F2D 329. It's a Second Circuit case, but they refer to the Speedy Trial Act in the federal system that imposes a unitary time clock on all co-defendants joined for trial. United States v. Pena, 793 F2D 486, another Second Circuit case, finds as a result, delay attributable to any one defendant is charged against the single clock, thus making the delay applicable to all defendants. So they found that basically if a defendant brings a motion to sever, which is denied, a reasonable delay analysis is applied in determining the reasonableness of any delay. Even under this standard, several federal courts have found delay alone isn't enough to establish prejudice. And again, what they continue to come back to is that joinder of trials is favored. They have found judicial economy is paramount and that the state should not be required to bring forth the same evidence in multiple trials when it could be done in just one trial. And in United States v. Casas, it's a Fifth Circuit case, 425 F3D 23. They found because the general rule is that those indicted together or tried together to prevent inconsistent verdicts and to conserve judicial and prosecutorial resources, severance is particularly difficult to obtain, whereas here multiple defendants share a single indictment. They went on to find that one of the defendants that had attempted to have his trial severed, that even though his trial may have been speedier had it been severed, the delays did not cause significant prejudice, nor did they result in the denial of a fair trial or a miscarriage of justice. They went on to just state the appellant must show prejudice greater than that which necessarily inheres whenever multiple defendants are tried jointly. And in this case, I think there's just some potentials thrown out by the defendant. I don't think there's been a definitive showing that there is any prejudice. One, I think one of the arguments here is the delay, but I think case law favors that delay alone is not enough to sever a trial. And the state in no means believes that the trial should be held in perpetuity, but we have a trial date right now. There's been no indication that Ms. Daybell is going to ask to continue that if it turns out that she is able to proceed forward. In addition to that, the defense has proffered to the court or indicated that there is a chance that some evidence may be attempted to be used against Ms. Daybell that deals with some issues in Arizona, and saying that if that were used, it would be prejudicial against Mr. Daybell. I think that's premature at this point. It's just an assumption or a speculation that that could happen. There are other appropriate ways to deal with that to determine if there is going to be evidence, such as a 404B motion to determine if it is applicable, if it is coming in, and if so, who that evidence would come in against. There are other things that courts have done to make sure that they're protecting one defendant's rights when there are joint trials. There have been cases in Idaho where a dual jury trial system has been used. There is case law saying that a dual trial system is not necessarily favored, but that it is not necessarily wrong to do that either. There are also times where maybe there are limiting, especially what we see as the most common remedy and what the courts have favored is limiting jury instructions. And they have found that the benefit should be given to jurors that they will follow those instructions. We shouldn't simply say that a limiting instruction, there's no way that it would be good enough. And so I think right now with the minimal issues that have been raised at this point regarding any potential evidence, they're hypothetical at this point. We don't know. And if there were to be any evidence that would come in only against one defendant, the courts have consistently held, and it's outlined in our brief very specifically, that a limiting jury instruction is favored and is often plenty to cure any of that. And it has been used repeatedly by courts to deal with that issue when evidence would only be applicable to one defendant and not the other. Obviously, the other concern, as we talk about judicial economy, I think one of the things that we would point out as well is in a case of this magnitude, requiring the state to present two different trials obviously would have a significant impact with regard to costs for the counties involved, as well as time for all the witnesses. This is a trial that has been set for 5 weeks. The anticipation being that 2 of those weeks will be for jury selection and another 3 for the actual duration of the trial. If the state were required to replicate that same trial, obviously we are looking at the potential for another 5 weeks.
It's actually already set for 10 weeks, I believe.
Oh, 10 weeks. I apologize, Judge.
Right.
I was definitely shortening that down.
Yeah.
So I appreciate that correction. And I think, so with that, we would be looking at the potential for 20 weeks that the state would have to replicate the same evidence, essentially, require us to call all the same witnesses, require us to use all the same staff and resources to do those trials. So I think that judicial economy definitely plays into this case. I think as outlined in the rules, the burden is is clearly attributed to the defendant, and it is a heightened burden to show that the only remedy would be to sever the trials. And it is a pretty, it is a unique remedy, considering what the courts have put out. In addition, one of the most common things that the courts look at, as the court already raised the Bruton issue, and I think we've addressed that. We addressed it both in our brief and here today, in indicating there simply is not a Bruton issue at this juncture. The defense has not raised a Bruton issue. They have the statements. Obviously, as I indicated, discovery is ongoing. If at any point statements are obtained, the state recognizes our requirements to immediately get those turned over to defense. And again, we recognize that that could raise a different issue, and we would need to deal with that at that time. The other thing that the state would indicate is a reason for severance, or has been found as a reason for severance, is if the defenses are completely antagonistic. In this case, there's not even been an argument or an issue raised with regard to the defenses being mutually antagonistic. And we outlined in our motion as well, but the courts have held that for them to be antagonistic is more than just defendants having a different take on the case, but that most courts have held that the defenses have to be so antagonistic that in order to find one party guilty, or one party guilty, the other party would have to be innocent, or vice versa. That it is such that if one defendant essentially puts on such a great defense, or that the evidence is not there to convict them, that it automatically convicts the other defendant. So those have happened in cases in which both defendants essentially claim it was the other one, and there's nobody else that it could possibly be. However, courts have looked at cases in which defendants have pointed the finger at one another as being the culpable party, but there was a third party involved. And the courts have found that by having that third party involved, simply pointing the finger at each other and blaming each other does not make the defense mutually antagonistic, because a jury could rationally and reasonably find that neither party was guilty. They don't simply have to find if one's innocent, the other is guilty by believing the evidence presented to them. They could believe that it was a third party or the other individual. So even if an antagonistic defense were raised in this case, unless it's to the extreme, it does not necessarily require severance. So I think given that, it appears that, again, the main arguments raised by the defense is that there's the potential for some evidence to be admitted against Ms. Daybell, which would not be appropriately admitted against Mr. Daybell. I think the case law clearly supports that if that is the case, the state can simply provide an appropriate jury instruction, limiting jury instruction with regard to that. And then it appears that the main crux outside of that would be whether or not there is prejudice based on a delay of the trial. And again, the state's position is when you're dealing with co-defendants, the federal courts, and again, we recognize they have a different clock, but they have established that the clock counts against both defendants, that there may be delays by some defendants, but that those delays alone are not enough without a showing of how it actually is going to prejudice the defendant. I don't think the defense has even put on any kind of argument or evidence today that even if the trial were to be delayed, which that's not where we're at this point in time, but even if the trial were to be continued, I don't think there's been any showing of how that would delay the defendant. There's been no argument that it would change the evidence, or that it would require that, or that they would lose evidence, or that there would be anything else which would require such extreme prejudice to force a severance. And again, part of what the state's looking at there is there has been a written waiver of speedy trial filed in this case. And with that waiver of speedy trial, Mr. Daybell has waived the right to essentially use that as his argument. And that is in State v. Youngblood 117, Idaho 160. And it was the Idaho Court of Appeals. They state, an unequivocal written waiver of speedy trial signed by a defendant is dispositive of a later motion to dismiss on this basis. So I think if that's going to be part of the argument is the delay, the fact that we have that written waiver of a speedy trial actually indicates that that would be an improper reason to bring a motion to dismiss down the road. And the state feels it would be an improper argument as well for why a severance would be necessary or why it would be prejudicial. And And I guess the last thing with regard to the speedy trial is I would indicate that there has been a test set out. It's a 4-factor balancing test. It was set out in Barker v. Wingo, 407 U.S. 514, to determine whether speedy trial rights have been violated specifically. And it indicates the court must balance 1, the length of the delay, 2, the reason for the delay, 3, whether the defendant asserted the right, and 4, the defendant suffered prejudice as a result of the delay. So at this juncture, there is no length of delay. There has been no request by Ms. Daybell to continue the trial. We are unsure of the status of her case, but there has been no delay based on that. Because there's been no delay, we don't have a reason for a delay. The defendant, whether or not he's asserted the right, he's actually waived the right. So number 3, we know the answer to that one, and whether he suffered prejudice as the result of a delay. Because there has been no delay at this juncture, he has not suffered any prejudice. So again, any argument with regard to a delay in the case is premature at this point, simply based on the fact that Ms. Daybell's case, or her case number is stayed, her trial remains set for January, the same time as Mr. Daybell's case. So given all of those reasons, the state believes that the defense has failed to meet any burden the heavy burden that they have under Rule 14, especially that heightened burden when we're dealing with conspiracy cases, since conspiracy cases more so are favored to be joined for trial. And given the considerations in looking at the interest of all parties involved, which the courts have looked at previously, and the interest of keeping trials together, we believe at this juncture it is more appropriate that the trials remain together. Again, the state recognizes severance is an issue that may be raised at any juncture. We are asking that if there is a decision issued, first we are asking that the court reserve ruling on it to allow Ms. Daybell to weigh in, because whether or not the case is severed affects her trial rights as well. If the court is inclined to issue a ruling before then, we are asking that it be done without prejudice, and that's to preserve all the parties' rights in the case. Again, as the court brought up the Bruton issues, at this juncture there are none. We recognize that's evolving, so it's also we would feel that it would be fair to have that be without prejudice with regard to Mr. Daybell as well. If new evidence or information is raised, we understand that all parties may need to be heard on different issues again. But again, we believe it would be premature to make any ruling based on hypothetical evidence that may or may not be asked to be entered without any kind of decision as to who that evidence would be applicable to. In addition to the fact we believe it's premature to make any ruling with regard to a delay or prejudice with regard to a delay, since there has been none at this point in time. So I believe that concludes the state's arguments, unless the court has any questions.
All right, thank you, Ms. Blake. I don't have any follow-up questions for you at this time. Mr. Pryor, would you like to make any rebuttal argument?
Judge, just very briefly, I've also taken the opportunity to look at the case law, and I want to make a differentiation between a couple of things that Ms. Blake had mentioned. There is a big difference, Judge, between a delay, which is referenced in every case Ms. Blake talks about, and uncertainty. And there is a difference between delay and uncertainty. And in the case of Ms. Daybell, there is uncertainty. We don't know what's going to happen in the future. Now, I would remind the court that my recollection, and the court, please correct me, but my recollection is the motion to sever was filed, I believe, in September. I believe that's when I filed this. So for the month of September, October, November, December, January, February, and now we're into March, that uncertainty has stayed there. Now, Mr. Daybell has been in custody, and I understand Ms. Blake is saying that a waiver of speedy trial is not prejudicial, but that only applies towards a delay. That case law does not apply to uncertainty. And uncertainty means that we don't know where we're going to be in a month, 2 months from now, and potentially 6 or 8 months from now. And the time to find out whether or not we're going to trial in January of 2023 is not the beginning of January of 2023. And Mr. Archibald is not able to file anything. Ms. Blake has said, well, Ms. Daybell's attorney could file things. No, he can't. He's not allowed to file anything during the stay. He can't file a motion to sever. He can't file a motion to change venue. He can't file a motion to continue the trial. He can't do any of those things. He has to sit there and wait like everybody else and find out what's going to happen in her case. And that's the uncertainty. And that's where the difference is, Judge, is the amount of uncertainty. Now, with all respect to Ms. Blake, I don't have to accept her position that there's no Bruton issues. I'm aware, when looking at the evidence, that there are a number of instances where Ms. Daybell makes statements to the police and other folks, and there are a number of instances where Mr. Daybell was interviewed by the police. And I'm not allowed, given the court's current order, to go into detail. So it seems a little disingenuous that they're going to say, well, you haven't provided any facts. Well, I'm not allowed to provide any facts because I'm not allowed to talk about the discovery, which is why I asked specifically that if the court feels that the uncertainty is not enough to sever these cases, then maybe the court should ask for the prosecutor to turn over all of the statements that they intend to use for trial, and the court can make its own independent assessment.
Okay, Mr. Pryor, I want to make a correction there. You're not prohibited from talking about the evidence to me. It's prohibition to third parties.
And Judge, this thing is being broadcasted on YouTube
everywhere.
And if I make a statement on YouTube about the evidence, I believe I'm in contradiction of this court's order.
Well, and you would be, and that's why I raised the issue earlier, that if there are specific issues we need to discuss outside of the
say the breakout, or shut up.
It's called a breakout room on Zoom or a sidebar that's out of the presence of the general public.
And my preference, Judge, and I put that in the motion, is that the court would require the state to turn over all the statements, and I would defer to the court's wisdom as to whether or not they feel there's any Bruton issues, which is how I thought Mr. Daybell and I discussed how we would like to handle that. But it still goes back to the original argument, Judge. The uncertainty of what's going to happen in Lori Daybell's case is a big difference than the delay of any trial. So at this point, I would ask the court to issue a severance order, sever these cases.
Nope.
And I don't want any delay, Judge. We need to have some sort of certainty, just like some of the other motions coming up. We need to know how we're going to be handling this case, and we need to go relatively quickly. We are 9 months out, and there needs to be some certainty as to which direction we're going to go, whatever that decision is by this court.
All right, thank you, Mr. Pryor. Ms. Blake, if you have any brief counter rebuttal, you can offer that at this time.
Thank you, Your Honor. I think the state would just, again, and I think the court's already inquired of the state, we do not have any statements in our possession. When you look at the Bruton case law, we don't have the type of statements that are addressed by Bruton. As Mr. Pryor indicated, he is in possession of multiple statements. I think Rule 14 from the state's perspective does not call for or require the additional burden on the state for us to compile any and every statement that a defendant may have made to anybody, to any third party or any witness that the state would intend to use at trial. I think when we provide discovery, there's the assumption that the state may intend to use any of that discovery or evidence at trial. Mr. Pryor's already indicated he is in possession of those statements. So I think the defense already has any statements that they may be concerned about, which I think we could go out of the public purview to talk about any specific statements if he wants to address those with the state. We are not aware of any that we believe would arise to a Bruton issue. If Mr. Pryor feels different, it sounds like he's in possession of those statements already. And I think we could discuss them off the record so that the state could be aware of them. I don't think Rule 14, though, calls for or requires that the state have any additional burden added, that we essentially prepare every statement that we may want to use at trial at this juncture and provide them to the court. If the court were to require that of the state, I would indicate, given the voluminous amount of discovery and the multiple statements that may have been made to third parties or any individual in this case, would take the state a significant amount of time to delve through again to make sure that we did not miss any statements. But again, none of those statements involve Bruton issues. So I think it would be an extra burden on the state to require that. But if so, then we would need to request that we set these proceedings out a significant period of time to allow the state to make sure that we review all discovery thoroughly to make sure that we don't miss any potential statements that we'd have to guess that the defense may think are somehow incriminating or would trigger the Bruton issues. So if the defense is in possession of those, I think we could go out of the public purview and talk about those, or they could be provided by the defense to the court or the state, so that the state is aware that they consider those concerning, and or the court. I don't think Rule 14 prohibits the defense from providing statements that they have concerns about, but the state simply has none at this juncture. And then I would just indicate, just to clarify, the state has not indicated, or if there was an appearance that we indicated that Ms. Vallow, Daybell's attorney, could file anything at this juncture. We did not intend to indicate that. The state is well aware that Mr. Archibald cannot file things at this juncture because of the pending stay, which is why we're asking for the reserved ruling on this matter, or that it be made without prejudice to allow Ms. Vallow Daybell to be heard at such time as she can, recognizing that at this juncture she's not able to be heard regarding this issue.
She's able.
So I did just want to clarify that with regard to those issues that were raised.
And Judge, I would like an opportunity to respond, seeing that it is my motion.
Just go ahead.
Oh, right. Yes. Sure, show.
And very briefly, Judge, I would, I believe that Ms. Blake is misinterpreting Rule 14. The rule simply says the court may require the prosecuting attorney to provide all statements that they intend to use at trial. Putting the burden on me to provide those to the judge isn't what the rule says. So at this point, if the court is even thinking that for some reason they shouldn't sever this thing, the burden is on the state. It's not on me, and Ms. Blake putting it on me is inappropriate. It's on them. And they don't get to pick and say, well, we don't think there's any issues there. But the court has discretion. The court can say, I want the statements or I don't want the statements. That's clearly within the purview of the court. But it's not within Ms. Blake to say, well, we don't have any Bruton issues, so we don't need to provide them. That's a total misinterpretation of the rule. The rule requires the state to provide them if this court deems them an issue important enough for them to review. I don't want any delay, Judge. I need a decision one way or the other as to whether this is going to be severed, because I have a significant amount of preparation that I'm going to need to do, and there's going to be an impact which way this goes. And this has been pending this motion's been pending for 5 months, and it hasn't changed in 5 months Ms. Vallow Daybell's position in terms of where she's at. We have no certainty as to where it's going to be in another 5 or 6 months. And I think it's inappropriate to put Mr. Daybell hanging in this situation with the idea that we don't have any certainty as where this is going. Given that, Judge, there's a difference between delay and uncertainty. And given the uncertainty, Your Honor, I would respectfully ask this court to sever the cases.
All right, I appreciate the arguments from everyone. I am going to take the matter under advisement at this time. I'll consider it submitted, and the court will issue a written ruling on the motion.
Thank you, Your Honor.
All right, anything else we need to bring up on the case this morning, Mr.
Victims would
Pryor?
like to speak.
I don't believe so, Your Honor. Thank you for your patience in this matter.
Oh, wait, they're not
Thank
here.
you, Mr. Pryor. Ms. Blake, anything further from the state?
Your Honor, the state was going to ask, and I think I'd leave it to the court, but I think we may be able to go off the record for this. But the state did just have a housekeeping issue with a hearing that we had set yesterday. We just wanted to clarify something with the court with regard to that setting.
Okay, why don't we go ahead and conclude this hearing?
Break out.
We will go off of the broadcast of the hearing on the YouTube channel. We'll have the court reporter included, however, and let's take up a breakout session where we'll make a transcript of that, and I'll just discuss that housekeeping matter with counsel.
And
so the motion to sever is concluded. If you want to go ahead and stop the live stream.
Now, and they dropped the mic. Oh my God. Wow. Eric. Eric.
Well, they didn't even
What was that?
They didn't even go into a breakout, did they? They just said it was over.
Yeah, they pulled a Jen. That's how Jen, she just boop. Mom says, what happened? Just woke up. A bunch of bullshit. Just a bunch of the same bullshit. Different day. Same trailer, different park, same toilet, different turd. I don't know. Go ahead. I don't know what happened. Just sound like a bunch of bullshit.
Well, Pryor he wants an answer like yesterday, and
No,
he's
so
not going to get that. And there's a bunch of evidence that he wants to see as far as any statements that have been made by anybody that are going to be used as evidence, in which the state replied that they don't have any at this time, but if they do come up, because the investigation is still ongoing, if they do get statements or whatever, they will all be kicked to the defense. So he'll get what he's got coming. I mean, that's
well, good. I hope it's that she gets her ass in the damn game. I hope. That's what I hope. I don't know. Again, I really don't even know. I just sit there and I respond. I don't know. I could really say so. Y'all don't ever want to hear me commentate. I was
well,
trying not to.
he split hairs with the.
He's a damn visionary. He can't see into March, April, May, June, July, and all the rest of the freaking months on the calendar. That's where I'm like, well, he's a visionary man. He can see the future, the past, the present. I mean, don't we all know this?
Yeah.
I go with sarcasm because it dictated how my family was murdered, because he was such a damn visionary. He just triggers me. Chad sitting there. He actually made some faces. I can't believe. I was shocked. I was like, yeah, Carolyn Dillman says, maybe he lost his pendulum. I bet. I asked Jason the other day, I said, do you think he sits there and thinks of his owl pendulum? I wonder if he was wearing it when he got arrested and it's in state, in the evidence when they make him change into the jail attire.
I gotta remember, because I want to go back. Shit. They already took this recording down.
Okay.
I'll have to go somewhere else, and
That's okay.
I want to go back and listen to that part about the Arizona evidence that is pending.
I have it still
In Arizona.
I have it. Listen.
Give a defendant's right to continue their trial.
Oh, no.
Okay,
Nope.
cool.
It went away. This video is unavailable. You heard him say about YouTube. If I say something on YouTube, and like Mom said yesterday, he's probably learning how by watching YouTube, how to defend.
And the thing is, I mean, Boyce said it at the beginning. Anything that's going to be skirting, her mental health stuff.
Yeah.
If we're going to do that, we're going to do it in a breakout. But Pryor evidently didn't hear that.
Mm-hmm.
I'm trying to think. It's very voluminous, Kay. The amount of stuff that he's going to have to go through to make his decision. He didn't give a date as to when, or even a guess as to how many days it would be before he gives his decision. I'm kind of flustered right now.
Yeah, I get it. I see, I don't know if KJ, what she gleans off of it. I want to know what she got from it. So KJ, if you have that link, come back on,
Can you drop it in the chat again?
Yeah, I'll try. Let me go.
Because Mikhail wanted to come back on too. I see.
Okay, hold on just a second.
Is she still in the chat? I'm not sure.
Copy. And
I didn't record it on my phone this time because since they left that one up yesterday, I thought they would leave this one up, and I was going to record it later.
Oh, okay, there it is.
Whoop, there it is.
I thought you knew. Oh man. Okay, let's read some of the comments. Let me see. Carrie Livingston, she said, yes, Pryor was trying to sound politically correct in that moment. I know, right? Ugh. It's so gross. KJ, Arizona evidence is on Lori, not Chad. So Pryor says it makes Chad look good. Nothing makes Chad look good.
Which
He don't even make himself look good.
Which is all premature. That's why I started nicknaming him Premature Pryor, because he prematurely argued about
something that wasn't even bringing it up. Yeah,
about his case, Chad being linked to a case in Arizona. Well, we just found out that they threw that out, so he's not connected in Arizona to anything now. And he was premature. He prematurely argued about, oh my goodness, I forget what it was. Something.
Wait, you know what? I've got it still playing in my background here. Hold on. I wonder, I can back up in my video that's live and get to it. Do you know about, you're not going to know what Minute Market was, huh?
No.
Do y'all want to listen to it again, and I'll just play it in the background here? Let me know if y'all would like to do that.
I don't mind if
I know you get a better, like a, instead of living in the moment, you kind of get a. Hold on, I'm trying to get to it. Come on, there it is. Okay, I gotta turn my TV up because it's on my TV. Oh, I hope it's not gonna go blah 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 blah. I hope not. If it does, I gotta shut it up.
I don't have any audio.
I don't either.
All right, good morning, everyone. This is KCR 22.
Let me move my mic over there.
2116.
I can't.
2-3 State versus Chad. Guy Daybell. Mr. Daybell is present, represented by his attorney, John Pryor. The state is also present, too, with prosecutors. Ms. Lindsay Blake will be arguing, I understand, on behalf of the state at the hearing today. This matter is being recorded on the court's FTR system, as well as this Zoom hearing. We're conducting it remotely. It's also being live streamed on the court's YouTube channel for public access to this hearing. At this time, then, the court has scheduled for this morning a motion to sever. The motion to sever was filed on the 9th of September 2021. Thereafter, a brief in support of the motion to sever was filed on February 9th. The state filed a brief in objection and opposition on February 24th of this year. The court would note that on May 25th, 2021, in this case, a single indictment was filed in the case, which included charges against both Mr. Daybell and also Noreen Vallow, including multiple counts that have conspiracy charges. And so the court has previously gone through and ruled that the cases are joined pursuant to Rule 8B of the Idaho criminal rules. And so this motion for severance was made with the defense request that the case or the defendants be severed. So at this time, Mr. Pryor, are you ready to present an argument in support of your motion?
Yes, Your Honor.
Okay, you can proceed with your argument.
Thank you, Your Honor. Judge, in this particular case, the two cases, as the court pointed out, were joined by this court. Subsequent to that, there was an order that put a stay on Miss Noreen Vallow's case. I am not afforded the opportunity to get any information about the status of the Noreen Vallow Daybell matter, and I don't have information as to what her status is. However, I do know that the stay is still in place, and I've not yet seen a transport order that would transport Miss Vallow Daybell back to Madison or Fremont County. I can only presume at this point, Judge, that there is still a stay and that there hasn't been any determination by this court as to what's going to happen in her case. The reason that's concerning, Judge, is that we do have a trial that is set for January, I think it's January 9th of next year, and it's fast approaching. There's a significant amount of preparation that needs to be done, and that preparation is going to include whether or not the cases are severed or whether they're joined together. And I'm not going to get into tactics, but I can assure the court that there is going to be a significant difference between how I prepare in the event the cases are joined as opposed to whether they're separate. In addition, Judge, I noticed that Ms. Blake in her response said that the only issue is Ms. Noreen Vallow's mental state. If you look at my pleadings and you look at my motion, Judge, I also made note of the fact that there are some additional charges that arise out of Arizona. Those are charges that Mr. Daybell, at least if I believe what the press is saying and the prosecutor, Mr. Daybell has is not being considered for prosecution in either of those cases, although Ms. Noreen Vallow is. My concern is that there's a lot of evidence, Judge, and with this court putting the limitation on my ability to discuss specific facts as to what facts I want to rely on to say this is why it needs to be severed, I put in a blank way, Judge. I said, Judge, I'd like the prosecutor, and under the rule, be required to provide their exhibits that they intend to use and allow the court, if the court needs that, to make an evaluation as to whether there is a significant conflict and whether or not it would have some sort of prejudice in either side, be either Mr. Vallow or Mr. Daybell presenting their case. So it's not
on that point, the rule doesn't indicate anything about exhibits. The rule is pretty narrow in scope of what may be provided in support of a relief for prejudicial joinder under Rule 14, and that's whether or not there are any statements or confessions. It's narrowed in scope to that, is the way I read it, and I think the way the case law interprets it.
And it is, Judge, and the rule says the court may. It doesn't require the court to turn over the statements, but I guess the word exhibits, I guess I intended to mean in terms of statements or confessions or items of that type of matter. So my motion...
I guess on that point there, then the state has indicated that you've been provided most of or all of the discovery at this point, and I guess getting right to that issue then, if there are any particular statements or confessions that are involved in this case, I would think those would be something the court would consider, but I've not received any notice of any of that.
Okay, and Judge, I guess I would refer the court to the rule, and the rule doesn't say provided to defense counsel. That's correct. I've been provided the majority of the discovery. There are some issues as it relates to that, but the rule says that the court may request that those statements be provided to the court. It does not say it's provided to defense counsel. It says provided to the court for the court to make a determination. So the rule does allow the court to require the prosecutor to turn over those statements. But Judge, the issue still primarily is the issue of the mental capacity of Ms. Vallow. So given that, Judge, I'll defer to Ms. Blake and allow her to make her argument.
Oh, that's awful. What kind of?
All right, thank you, Mr. Pryor. Ms. Blake, argument from the state, please.
Thank you, Your Honor. And I think to start off with, what the state would indicate is we do recognize that we are arguing the motion to sever today that was filed by Mr. Daybell. However, the state is requesting that the court reserve ruling on this matter until more information is available to the court and the parties regarding the stay in the co-defendant's case, which these are one case for trial. So when I say the co-defendant's case, I'm simply referring to Miss Lori Vallow Daybell's case, which is Fremont County case number CR 22-21-1624, and it is the companion case for trial. It is the state's position that it would be most appropriate in the interest of judicial economy and to preserve all rights of the parties that Ms. Daybell also be allowed to be heard regarding a motion to sever, since this also affects her trial rights. That being said, we are not asking for an indefinite delay on any ruling from the hearing today, but we feel that any information that may be available to the court and the parties hopefully fairly quickly would be useful in making a decision regarding the severance, and also wouldn't infringe upon the rights of either of the defendants in this matter.
Okay.
So
Let me address that point then. So regardless of her status, competency or not, I assume that hasn't changed the evidence you've got in the case. And I guess the issue here is whether or not there are statements or confessions which you think the court should review in order to make a determination under the rule. And I do agree with Mr. Pryor. The rule pretty clearly states that if that's going to be ordered, that it's ordered that the attorney for the state deliver to the court that information. And of course, that's not something that would need to necessarily be disclosed here in public, and we've got a sidebar, but I do want to know whether or not there are statements or confessions that need to be considered in making the determination, and not learn that at the time those are coming up at trial. So in your evidence, do you believe there are any of these statements or confessions which go to the Bruton issue and many other issues which require me to weigh that out to make a decision?
Your Honor, the state does not believe that there are any statements. We do not have any statements that we intend to use at this time that would fall under the Bruton rule as the state understands it and has reviewed the case law. As the state indicated in our brief, we have provided voluminous discovery to Mr. Pryor. We've provided everything within the state's possession at this time. Of course, discovery can be an ongoing process, and this could change at some point, but at the current time, there are no Bruton issues. There are no statements that the state intends to introduce which would trigger a Bruton issue. And so what the state had pointed out in our brief is, while we recognize that Rule 14 can place that burden on the state, I don't think there's been any indication by the defense or a real issue raised with regard to them believing, the defense believing, that there are Bruton issues in this case or any statements, and they have access to the statements that we have access to. So from the state's perspective, no, there are none, and the defense already has the statements that the court has in our possession. When we look at the cases that delve into that Bruton issue, can indicate at this time we do not have any custodial statements. So at no time after the parties were Mirandized do we have any incriminating statements one way or the other, which we would intend to use. At this point in time, well, we wouldn't intend to use them because they simply don't exist at this juncture. And again, of course, that could change. It's always an evolving issue, which is part of the reason the state thinks it may be beneficial to preserve the ruling on severance, since a motion to sever can be raised anytime before trial. And and as this case evolves, we recognize that it could go one way or the other. In addition to, if the court is inclined to make a ruling at a sooner period of time than the co-defendant, Ms. Daybell's case, can move forward, we think it would be appropriate for any ruling to be made without prejudice to allow the parties to re-raise the issue. Ms. Daybell may or may not want to raise the issue, and depending on where her case heads, the state may or may not feel that it is necessary to re-raise the issue, or depending on the outcome, if there is more information gained down the road, Mr. Daybell may want to re-raise the issue, depending on the ruling of this court. So we would be requesting that just at the outset.
That was it.
And I don't know if the court wants to hear the argument regarding the severance itself, or if we were just addressing whether or not the statements needed to be turned over.
Yeah, I interjected with that issue, but I would like to hear the remainder of your argument on the severance motion.
Thank you, Your Honor. And the state did file quite a lengthy brief in this case, and so I don't want to belabor those points too much. But the state's position in this case is the first thing that we start with is under the Rule 8, and this court has already indicated these were joined under Rule 8B. It's the state's position that these were properly joined. I think this court, in its August 6th order and at subsequent hearings, has made indication that the joinder in this case under Rule 8B, when we're dealing with the co-defendants, was permissible. If it's been determined that under Rule 8B a joint trial is permissible, a defendant can always raise a severance under Rule 14, arguing that the joint trial would be prejudicial. And that appears to be what the defendant is arguing today. However, case law makes very clear, and looking specifically at State v. Gamble, 146 Idaho 331, it states the defendant has the burden of showing such prejudice. When we delve further into the case law, and the federal courts seem to deal with this issue more so than the state court, at least the Idaho State Court. The Supreme Court has also addressed it. And in United States v. Fair, in United States v. Contreras, that is not the right citation. I apologize, Judge. As the federal cases go through this, though, I would indicate that Federal Rule 14 is worded very similar to the Idaho rule, providing that the court may order separate trials of counts or sever the defendant's trials or provide other relief that justice requires if there is prejudice. In Richardson v. Marsh, 481 U.S. 200, the United States Supreme Court has found that joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. That joint trials also enable a more accurate assessment of relative culpability advantages, which sometimes operate to the defendant's benefit. And in addition, joint trials avoid prosecutors bringing separate proceedings, presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. The defendant, the Ninth Circuit Court of Appeals, has stated the defendant bears the heavy burden of demonstrating that the joint trial was so manifestly prejudicial as to require the trial judge to exercise his discretion on the motion to sever in just one way, by ordering a separate trial. And as we continue to go through the case law continues in both the Ninth Circuit, the federal courts in general, the United States Supreme Court, and the Idaho courts continually indicate that the burden is on the defendant, that it is a significant burden, and especially when we're dealing with cases of conspiracy. In cases of conspiracy, joinder is favored. The reason being, again, for judicial economy, we are dealing with a lot of the same witnesses, the same evidence, and there is overlap. The courts have even found that joinder is favored so strongly that even if at the end of the day, the charge itself that would require the joinder, so such as a conspiracy charge, even if the defendant is not found guilty of that, it does not make the joinder improper or a court's decision not to sever suspect in that particular situation. I think Mr. Pryor had indicated that the state raised that the only issue dealt with Miss Vallow Daybell's mental health. That issue wasn't actually raised by the state. Where the burden is on the defendant, the state has simply responded to the brief and to what appeared to be the arguments that would be made by the defense today. In the brief, there were no specific issues outlined in defendant's brief. It appeared that there were some things alluded to. One of those appeared to be the stay in Miss Vallow Daybell's case. It is the state's position that it is inappropriate to consider the stay in her case as a reason to sever at this juncture. Again, these cases have been on separate tracks, so Mr. Daybell has had the opportunity to be heard and to file motions, while Miss Vallow Daybell at times has not had that opportunity yet to be heard on some of those motions. Which is part of the state's rationale for asking that any decision in this case be reserved. But regardless, we believe that until a decision on the stay in her case is made, it would be premature to factor that into a decision to sever the cases. And when we look at some of the cases in the federal system, they deal with this issue and they talk about, I was trying to get to the exact case, but it's in our brief, and they do talk about the stay in the case being attributed to all the co-defendants potentially and accounting against their speedy trial clock in the federal system, which is calculated different. But the courts go on to talk about
the United States Constitution that can be a factor, but that it is not necessarily a violation of a defendant's right to continue their trial in order to have a joint trial with a co-defendant. And it would be the state's position in this case, and I think we've raised this before, but with regard to any speedy trial issue and the right to speedy trial of a defendant, Mr. Daybell, expressly waived his right to speedy trial. He filed a signed written waiver of speedy trial. And in Idaho, the courts have found that once a waiver of speedy trial occurs, that issue cannot be raised down the road as an issue for a delay in a trial or a reason why the trial hasn't been held faster. And I did find the case that I was referencing. So United States v. Vasquez, which is 918 F2D 329. It's a Second Circuit case, but they refer to the Speedy Trial Act in the federal system that imposes a unitary time clock on all co-defendants joined for trial. United States v. Pena, 793 F2D 486, another Second Circuit case, finds as a result, delay attributable to any one defendant is charged against the single clock, thus making the delay applicable to all defendants. So they found that basically if a defendant brings a motion to sever, which is denied, a reasonable delay analysis is applied in determining the reasonableness of any delay. Even under this standard, several federal courts have found delay alone isn't enough to establish prejudice. And again, what they continue to come back to is that joinder of trials is favored. They have found judicial economy is paramount and that the state should not be required to bring forth the same evidence in multiple trials when it could be done in just one trial. And in United States v. Casas, it's a Fifth Circuit case, 425 F3D 23. They found because the general rule is that those indicted together or tried together to prevent inconsistent verdicts and to conserve judicial and prosecutorial resources, severance is particularly difficult to obtain, whereas here multiple defendants share a single indictment. They went on to find that one of the defendants that had attempted to have his trial severed, that even though his trial may have been speedier had it been severed, the delays did not cause significant prejudice, nor did they result in the denial of a fair trial or a miscarriage of justice. They went on to just state the appellant must show prejudice greater than that which necessarily inheres whenever multiple defendants are tried jointly. And in this case, I think there's just some potentials thrown out by the defendant. I don't think there's been a definitive showing that there is any prejudice. I think one of the arguments here is the delay, that I think case law favors that delay alone is not enough to sever a trial. And the state in no means believes that the trial should be held in perpetuity, but we have a trial date right now. There's been no indication that Ms. Daybell is going to ask to continue that if it turns out that she is able to proceed forward. In addition to that, the defense has proffered to the court or indicated that there is a chance that some evidence may be attempted to be used against Ms. Daybell that deals with some issues in Arizona, and saying that if that were used, it would be prejudicial against Mr. Daybell. I think that's premature at this point. It's just an assumption or a speculation that that could happen. There are other appropriate ways to deal with that to determine if there is going to be evidence, such as a 404B motion to determine if it is applicable, if it is coming in, and if so, who that evidence would come in against. There are other things that courts have done to make sure that they're protecting one defendant's rights when there are joint trials. There have been cases in Idaho where a dual jury trial system has been used. There is case law saying that a dual trial system is not necessarily favored, but that it is not necessarily wrong to do that either. There are also times where maybe there are limiting, especially what we see as the most common remedy and what the courts have favored is limiting jury instructions. And they have found that the benefit should be given to jurors that they will follow those instructions. We shouldn't simply say that a limiting instruction, there's no way that it would be good enough. And so I think right now with the minimal issues that have been raised at this point regarding any potential evidence, they're hypothetical at this point. We don't know. And if there were to be any evidence that would come in only against one defendant, the courts have consistently held, and it's outlined in our brief very specifically, that a limiting jury instruction is favored and is often plenty to cure any of that. And it has been used repeatedly by courts to deal with that issue when evidence would only be applicable to one defendant and not the other. Obviously, the other concern, as we talk about judicial economy, I think one of the things that we would point out as well is in a case of this magnitude, requiring the state to present two different trials obviously would have a significant impact with regard to costs for the counties involved, as well as time for all the witnesses. This is a trial that has been set for 5 weeks. The anticipation being that 2 of those weeks will be for jury selection and another 3 for the actual duration of the trial. If the state were required to replicate that same trial, obviously we are looking at the potential for another 5 weeks.
It's actually already set for 10 weeks, I believe.
10 weeks. I apologize, Judge.
Right.
I was definitely shortening that down.
Yeah.
So I appreciate that correction. And I think, so with that, we would be looking at the potential for 20 weeks that the state would have to replicate the same evidence, essentially, require us to call all the same witnesses, require us to use all the same staff and resources to do those trials. So I think that judicial economy definitely plays into this case. I think as outlined in the rules, the burden is very, is clearly attributed to the defendant, and it is a heightened burden to show that the only remedy would be to sever the trials. And it is a pretty, it is a unique remedy, considering what the courts have put out. In addition, one of the most common things that the courts look at, as the court already raised the Bruton issue, and I think we've addressed that, we addressed it both in our brief and here today, in indicating there simply is not a Bruton issue at this juncture. The defense has not raised a Bruton issue. They have the statements. Obviously, as I indicated, discovery is ongoing. If at any point statements are obtained, the state recognizes our requirements to immediately get those turned over to defense. And again, we recognize that that could raise a different issue, and we would need to deal with that at that time. The other thing that the state would indicate is a reason for severance, or has been found as a reason for severance, is if the defenses are completely antagonistic. In this case, there's not even been an argument or an issue raised with regard to the defenses being mutually antagonistic. And we outlined in our motion as well, but the courts have held that for them to be antagonistic is more than just defendants having a different take on the case, but that most courts have held that the defenses have to be so antagonistic that in order to find one party guilty, or one party guilty, the other party would have to be innocent, or vice versa. That it is such that if one defendant essentially puts on such a great defense, or that the evidence is not there to convict them, that it automatically convicts the other defendant. So those have happened in cases in which both defendants essentially claim it was the other one, and there's nobody else that it could possibly be. However, courts have looked at cases in which defendants have pointed the finger at one another as being the culpable party, but there was a third party involved. And the courts have found that by having that third party involved, simply pointing the finger at each other and blaming each other does not make the defense mutually antagonistic, because a jury could rationally and reasonably find that neither party was guilty. They don't simply have to find if one's innocent, the other is guilty by believing the evidence presented to them. They could believe that it was a third party or the other individual. So even if an antagonistic defense were raised in this case, unless it's to the extreme, it does not necessarily require severance. So I think given that, it appears that, again, the main arguments raised by the defense is that there's the potential for some evidence to be admitted against Ms. Daybell, which would not be appropriately admitted against Mr. Daybell. I think the case law clearly supports that if that is the case, the state can simply provide an appropriate jury instruction, limiting jury instruction with regard to that. And then it appears that the main crux outside of that would be whether or not there is prejudice based on a delay of the trial. And again, the state's position is when you're dealing with co-defendants, the federal courts, and again, we recognize they have a different clock, that they have established that the clock counts against both defendants, that there may be delays by some defendants, but that those delays alone are not enough without a showing of how it actually is going to prejudice the defendant. I don't think the defense has even put on any kind of argument or evidence today that even if the trial were to be delayed, which that's not where we're at this point in time, but even if the trial were to be continued, I don't think there's been any showing of how that would delay the defendant. There's been no argument that it would change the evidence or that it would require that, or that they would lose evidence, or that there would be anything else which would require such extreme prejudice to force a severance. And again, part of what the state's looking at there is there has been a written waiver of speedy trial filed in this case. And with that waiver of speedy trial, Mr. Daybell has waived the right to essentially use that as his argument. And that is in State v. Youngblood 117, Idaho 160. And it was the Idaho Court of Appeals. They state, an unequivocal written waiver of speedy trial signed by a defendant is dispositive of a later motion to dismiss on this basis. So I think if that's going to be part of the argument is the delay, the fact that we have that written waiver of a speedy trial actually indicates that that would be an improper reason to bring a motion to dismiss down the road. And the state feels it would be an improper argument as well for why a severance would be necessary or why it would be prejudicial. And I guess the last thing with regard to the speedy trial is I would indicate that there has been a test set out. It's a 4-factor balancing test. It was set out in Barker v. Wingo, 407 U.S. 514, to determine whether speedy trial rights have been violated specifically. And it indicates the court must balance 1, the length of the delay, 2, the reason for the delay, 3, whether the defendant asserted the right, and 4, the defendant suffered prejudice as a result of the delay. So at this juncture, there is no length of delay. There has been no request by Ms. Daybell to continue the trial. We are unsure of the status of her case, but there has been no delay based on that. Because there's been no delay, we don't have a reason for a delay. The defendant, whether or not he's asserted the right, he's actually waived the right. So number 3, we know the answer to that one, and whether he suffered prejudice as the result of a delay. Because there has been no delay at this juncture, he has not suffered any prejudice. So again, any argument with regard to a delay in the case is premature at this point, simply based on the fact that Ms. Daybell's case, or her case number is stayed, her trial remains set for January, the same time as Mr. Daybell's case. So given all of those reasons, the state believes that the defense has failed to meet any burden, the heavy burden that they have under Rule 14, especially that heightened burden when we're dealing with conspiracy cases, since conspiracy cases more so are favored to be joined for trial. And given the considerations in looking at the interest of all parties involved, which the courts have looked at previously, and the interest of keeping trials together, we believe at this juncture it is more appropriate that the trials remain together. Again, the state recognizes severance is an issue that may be raised at any juncture. We are asking that if there is a decision issued, first we are asking that the court reserve ruling on it to allow Ms. Daybell to weigh in, because whether or not the case is severed affects her trial rights as well. If the court is inclined to issue a ruling before then, we are asking that it be done without prejudice, and that's to preserve all the parties' rights in the case. Again,
Can you stop that?
the Bruton issues at this juncture, there are none.
And rewind about 10 seconds.
Sure. I'm sorry for me and my all that. Oh my God, it's bad.
I want to hear Lindsay say that again.
Okay. I'm going to go back 20 seconds.
Okay.
Allow Ms. Vallow Daybell to weigh in, because whether or not the case is severed affects her trial rights as well.
Yeah, just a smidge back further.
We're asking that the court reserve ruling on it to allow Ms. Vallow Daybell to weigh in, because whether or not the case is
more than that.
Right. No, that's what I wanted. I wanted to triple check.
They always say Vallow Daybell. I'm pretty sure.
If she wasn't back, I don't think Lindsay Blake makes that statement right there. She's asking him to reserve making his decision so she can have her input in on the severance also.
Okay.
Now that's me doing what I shouldn't do and trying to read between the lines.
Oh yeah, that's what you exactly should do.
But
that's what we all do.
I take that statement right there, what she just said, what she said, reserve his decision so she can have her input on the severance. And Lindsay Blake must know that decision is coming soon, because she's not going to ask for Judge Boyce to wait 30, 60, or 90 or 120 days for her. Does that make sense?
Yeah. Yeah, I get that. I've been watching chat too, and they're talking about the name changes and why, Lori would have used Daybell versus, it was just whatever fit her need at the time. I'm Lori Ryan. There's a lot of times when she used Lori Ryan to get plane tickets and portal everywhere. I guess that's a new word for portal, is flying.
Can I say something here?
Yes, please.
Big E, the judge will not delay a ruling that the state wants. He is going to submit his order. So this whole idea that this might point to reading between the lines about Lori's incompetence, and maybe she's fixing to be competent, and that the state knows that here shortly, not too far down the road, just delay it, Judge, delay it. Well, he done said at the end of the hearing, he's not delaying it. He's going to submit his ruling. So do you see what I'm saying?
Yeah, I see it.
Right, but here's the flip side to that. Her 6 months was up March the 7th. So we're 11 days past that now. The first time they extended her, they done it within 7 days.
Yeah, well, also there hasn't been any notification to the state or to the defense of a transport order for Lori, so it can't be. It's just my opinion. She is still in treatment. They're still trying to get her competent. That's what I think.
That was the other thing that jumped out at me too, was Pryor specifically mentioning a transport order. That because
wait, say that again?
Yeah, at the very beginning, Pryor says that he has yet to receive any documents for a transport order for her to be brought back
from the city back to jail, right?
Back to Madison or Fremont jail, yeah.
Oh, they're definitely tiptoeing around it. They know, the judge knows, the state knows, and the defense knows exactly what's going on with Lori right now.
But we don't.
And let me just say this, Big E, when you honed in on it perfectly about Arizona. I got a little bit of a different take on it. But when John Pryor brings it to the attention of the courts that Lori is charged in Arizona and not Chad, that is exactly the theory that I had presented, that they're going to look at the fact that Chad was not charged in Arizona, and they're going to say, see, our defense
for that murder,
Lori and Alex doing everything and framing Chad. See, Chad wasn't involved. How can he be conspiring with her if he didn't conspire with her in Arizona? Look, he ain't been charged.
Oh my God. Ew, it's so freaking gross and technical. Oh my God.
Yeah,
We
and
all
that's
know he was all to do with it. You know,
that's
he
Of
was
course he
one of
did, and it's a damn disgrace.
it
Chad
is.
Daybell should have been charged with a conspiracy to commit murder on Charles, and he
Yeah.
should have been. And this whole situation with Brandon, Big E, you talking about? You don't think it's ever going to be adjudicated? That nothing's ever going to happen? That is a damn disgrace.
that's going to be thrown out.
You think
Ain't
Brandon?
nobody going to be charged with that. If you have Chad Daybell and Lori Vallow both talking to Alex Cox as he's driving to Arizona to shoot at Brandon, you have that, and you've already dismissed Chad's case, then what the hell are you going to, Lori was talking to him too.
Yeah, well, I mean, what Chad just innocently wanted to put a tire in a seat in a
Yeah,
storage
Yeah.
unit the
And
day
help
of the attempt on the
exactly.
murder there.
like
Yeah,
Tampa
they're at the
Bay.
storage unit putting tires in. Chad's grabbing their ass, and everybody's all chummity chum, but the
Don't
drunk
anybody-
ass Maricopa DA threw it out.
Yeah.
Well, I want to bring up real quickly about this antagonistic defense. Now, they brought it up, and it sounds like a big high dollar word.
I'm not a
It's
Google.
my understanding that what the state is saying about that is finger pointing, right?
Yep.
They're saying that the defense can't. There isn't evidence there that shows prejudice in the aspect of wanting to point fingers at one another, to be antagonistic toward each other. So, I mean, what does that say about John Pryor's defense? I mean, if Chad's not going to point the finger at her and she's not going to point the finger at him, and he has no evidence of that, and the state is saying that, the state is saying there is no evidence that one is going to turn on the other, or that the jury can find only one guilty and one innocent. So right now, John Pryor, I don't know what in the hell he thought he was doing coming in there today. This was a big issue. Severance. He didn't talk about anything that he needed to talk about.
Yeah, I agree 1,000%. I was stunned at his lack of preparedness for it.
I mean, what, just to skip by this whole competency issue, and also he didn't even give any reason. He didn't even articulate a reason why it prejudiced, even if it was just an opinion, because an opinion's not evidence.
Right.
And he would have had to bring in there today, hey, this is the evidence I have that shows that my client is being prejudiced by sitting at the table with Lori. And this is the evidence that we have about that. He wasn't even all he was concerned about. He wanted to know if there was any further statements or confessions that might have come out of this since all of the discovery had been turned over. He was fishing for that. And the state confirmed that they have no confessions. They have no statements that are incriminating. So we learned that today. There isn't nothing further since the discovery's been turned over that points to Lori talking, or to, and obviously Chad's not talking, or Pryor wouldn't be asking the state for confessions or statements. And even the judge said that even if it came down to that, the bottom line is that the state was the one that wanted to delay on this ruling. They want to say it's because Lori needs to participate as well. But the judge specifically said, regardless of Lori's status, right now, the evidence is in, the discovery's been turned over. And he asked the state, are there any confessions or statements? He's asking,
Right.
is there anything further?
Right.
And they said no. So it really, it's a narrow way that you can get into severing a case once it's already been joined. A joinder is very hard to separate because the original stuff that John Pryor could even talk about was already talked about back when they joined the cases. And the state obviously today also brought up the same crap by saying it's judicial efficiency, it's all these things. We've heard this before.
Money.
So,
Yep.
I mean,
Always about money. I just found this really good article, and I'm typing it in right now on antagonistic defense. Oh my God! And
read it.
Well, I'm Y'all keep talking. I'm pulling it up right now. Oh yeah. Keep on talking.
I don't think that the state asked for all of these continuances in the last couple of days because of anything else other than they know that she'll be coming back.
Well, I'd love to believe that, but I'll tell you right now, the state has done, in my opinion, and this is just mine, they have drugged their feet too. And
I don't disagree with that. I mean, they've dropped the ball on some things, for sure.
Well,
God.
the state's position is that this case was properly joined from the get-go, that the judge ordered it, and the judge ordered it for whatever reasons he ordered the joinder of cases. The bottom line is there's only a narrow way, and that narrow way for John Pryor to get a severance of this case is to actually show that he can't just say it's prejudicing. He has to actually show evidence that this has prejudiced his client, and he hasn't done that. And the judge is not going to isn't going to listen to the state when the state says, let's delay this until Lori becomes competent. Basically, he's going to rule on it again. And it doesn't have nothing to do with Lori's competency, and it doesn't have anything to do with prejudice when you don't have evidence there either way. She is in limbo. She is up there. I'd love to believe you, Big E. I'd love to believe that she's almost fixing to be competent. But you know what? I've been shot down more than once, and I'm to the point now where I ain't gonna get my hopes up about any of it anymore. I'm just gonna go. I'm gonna try to take Cresha's line. She just is very calm, and she's very whatever may be. Que sera, sera. It's just incredible, really. It's unbelievable.
And that's fine. This is just my opinion and trying to read between the lines. That's all I'm saying. I mean,
yeah, and this whole issue about that John Pryor wants to bring up about this delay. Well, there isn't a delay right now, and even if there was a delay, the bottom line is that Chad expressly signed a waiver of a speedy trial, and it cannot be raised down the road. And so John Pryor on one hand wants to say, we don't have a problem, we'll sign this waiver so we don't have to get a speedy trial, and then turn around and say, well, this can hamper my defendant, my client. It's not going fast enough. Well, you can't have it both ways.
No. I just got a text message. I'm sorry.
That's all right. All I'm saying is I think we've learned a lot today. Everyone's going to believe what they're going to believe. Everyone's going to have a hope in what they believe. And no one really knows the factual answer. But if I had to read the tea leaves, Lori is still up there in the mental health facility. They're still giving her treatment up there. This whole issue about status pending inactive stuff that we saw last week that got me knocked off guard. The bottom line is, as the judge said it himself, it's still in a stay. And I thought it was out of a stay, but it's not. It's still the whole Lori's crap is still in a stay. There is no transport order. The state is not alluded to, even though I understand where you're coming from, Big E, that maybe this means because they said whatever they said, the state said, that makes it look like that maybe she's fixing to be competent. The bottom line is she's not transported to jail. And I'd like to put a foot up her ass. I'm just telling you.
And the text message that I just got from somebody that I'm really tight with, it says, also, I think Pryor let it slip today that he knows her status when he said he has not seen an order about her transport put in.
And he would have to be given that information. And he has every right to that information. And for the state to sit there and act like we don't know the status, and get for real. The judge knows because the Idaho Department of Health and Welfare has to report to him.
Yeah, that was another thing that kind of made my eardrums turn cockeyed. The state allegedly, Lindsay says they don't know her status. Defense doesn't know her status. So who the hell does?
The judge has to know her status because of the way that order was set up. And I'll tell you something right now. Maybe they just had to say that today for HIPAA reasons. Maybe they just was trying to make it seamless as possible through there. Maybe there was an understanding before the hearing. I don't know. I'm only speculating. But what I will say, if that is the case, if the state of Idaho has not gotten any information after we have already had reports of 2 doctors turning in reports, and the state is going to sit there and say they don't know, and the defense is going to say they don't know, and there is no, I mean, John Pryor, your friend, whoever that is that sent you the text, when John Pryor says no transport order, that you might as well be saying she ain't going back to jail. And if she ain't going back to jail, she is still being taken care of up there for however that works out, or for however long it's going to. But that says it all, really. And I was waiting for that. I was waiting for some kind of something that would indicate to me if this had anything to do with Lori on her way back to jail, we would know about it today. Just by the way they were talking, even if they were tiptoeing around it. And the bottom line is John Pryor let it out. And even he said during the hearing, he said, there are things I can't discuss or I'd be in trouble with you, Judge. And the bottom line is she's still up there, and she's a liar, and she's a malingerer, and she's going to get hers. And Chad Daybell can sit there all he wants, that toad face of his, and he can sit there and smirk and act like whatever he wants. The bottom line is Lori ain't putting moose in that hair anymore, is she? He don't look like the freaking guy standing on the beach marrying her ass with a ukulele in his hand, does he?
No.
I mean, did you see his hair today?
Yeah.
I mean, he looked like the poster child for generic hair club for men. I mean,
he got drunk. He got, hammered drunk last night after not getting his way yesterday.
He must have squeezed a potato. He
His
must have squeezed a potato and hid that stuff under his bunk or something. Because I'm telling you now, he looked rough. You couldn't see his shoulders. He looked slumpy. His coloring looked bad. He looked bad. He looked like, a toad would be more attractive than him. And he deserves every bit of it. And this goes back to what Krisha was saying. If he's such a dang prophet, if he's such a dang seeing beyond the veil guy that he is, a visionary, he sure as hell don't know where he's going now. Because I can tell you right here, the judge is going to let us know. The judge is going to let us know here within the next day or two. It'll be up there on that cases of interest. We'll get into it. We'll find out exactly what I know to be true, and that the judge is not going to sever these cases at the time. And the state even said at any time before trial, the issue can be brought up again, either by Lori or Chad. So it's not like one issue that they're going to decide on and it's could never be brought up again,
Yeah, I don't think that it'll be severed. I don't think you will.
I mean, can you imagine? The only way that there could be a severance is if the judge had knowledge that Lori was ready to have some kind of plea agreement, because then there wouldn't be no trial. They would be a plea agreement. And that's jumping the cart there. Basically what I'm saying is that's the only, if she got competent and decided, you know what, I'm competent now and I'm ready to plead out, and Archibald, it's your specialty, and will you help me through this plea agreement? And it ain't even got to be about her turning on Chad. It could just be her wanting to say, I want to plead guilty or whatever, not to the death penalty. I mean, of course, that would be taken off the table before any plea agreement, because the woman's up there in a nut house right now. No one's going to put her to death. No one's going to put her to death after she's been ruled incompetent. It's very rare.
Well, it's illegal. It's illegal to kill somebody who has mental health issues.
Well, now I don't know about that. There are a lot of mentally ill people that become competent that sit on that.
Yeah. As long,
I mean, there are everyday people that's got mental illnesses that know the difference between right and wrong.
right. I thought you meant people
Insanity defense.
that were still, crazy and had still been put to death. But no, that's a federal law. They're not. But if they've been restored, then obviously, yeah, they can.
Well, one thing's for sure, Chad and Lori both, neither one of them has confessed to anything. Neither one of them have made statements after the discovery has been put in. And this whole issue, now listen to this. When the state was talking about the defendants turning on each other, said that this would not apply. You couldn't use the antagonistic defense as a way to sever a case because, now listen to this, there was a third party involved. And who was that third party, Big E?
Alex?
That's right. And because Alex was involved, you can't, this whole pointing fingers thing can't be, you know what I'm saying? The pointing fingers isn't going to trigger a severance. In other words, Lori can't sit there in the seat and point at Chad and say, "You did it all, Chad. You did it." Or
Right.
Chad can't look at her and say, You got to my Johnson, Lori. I didn't know what I was doing. You did it all behind my back.
Right.
You know, Alex, everyone was saying if Alex would have stayed alive, then things would have been different. In some ways, I could see how they would use him as a scapegoat, but in other ways, it actually benefits the fact that Lori and Chad will never ever see freedom again. I just don't see it happening.
No, they won't. They're done. They're done.
And remember this: the burden is on John Pryor, especially when you've got criminal conspiracy. This is Idaho law. Idaho law says the burden is on the defendant in criminal conspiracy, highly favored. It's highly favored to keep this joinder together because of it. So John Pryor gave no reasoning. John Pryor was fishing today. John Pryor had no arguments.
Exactly right.
He had a lot of bluster, and he showboated a little bit. But the bottom line is his client is going right back to the jail cell to meet Bubba. And that's the way I feel about it.
Well, I mean, we'll find out. Hopefully, here real soon.
Well, this whole issue about Lori Vallow Daybell and Lori Vallow and Lori Daybell, I used to read into that thinking maybe the way they were speaking or whether it was put on the legal form, her name and this and that. I've gotten to the point now where it's all running together for me. I've become so cynical about all of this, and I just, if it wasn't for all the support of everyone emotionally supporting me to help me to stay strong for the victims' families and stuff like that, I honestly would just throw in the towel. But I want to see justice done, and I want to see, what I feel and what's going on with me about this case is nothing, absolutely nothing in comparison to what the victims' families are going through. Right. And so I have to keep that in the forefront of my mind too. So today's hearing was enlightening to me. I mean, I feel I'm pretty confident that Lori is still incompetent, or at least they're still working on her. And she's malingering, but the bottom line is that's the way it is, and there's nothing I can do about it or anyone else. She's not going back to the jail cell. And now I know this whole issue, why they can't tell us, it makes no sense at all. Because they could tell us they put her in there. They can tell us that they gave her an expansion on her time there.
Oh, I was muted the whole time.
Yeah, I mean that's my whole argument is they didn't have any trouble telling us she was going in twice.
Right.
So why all of a sudden it's got to be kept a big secret the third time. That's
They don't.
my whole point.
I found
And 11 days passed when her 180 days was up. That's the whole basis for my opinion as to why I think that she's competent. They're waiting on some things to be heard, and she'll be back. But that's just my opinion, and I'm basing it on the last two times that we went through this. It was bang, bang, bang.
Well,
And
I
she,
hope you're right. I'd love for you to be right. Maybe you are right. I've been dang
Oh,
a
thank you,
wet
Heidi.
blanket. You know, I've been a wet blanket about all this. I'm just telling y'all. I'm at this point where I just wish that, you know, we could have more transparencies, basically. What I just
Exactly.
Oh, absolutely. Preach, sister.
Thank you, Heidi. That's so generous. Thank you. I'm sorry.
Hey, the bottom line is all discovery's been turned over.
Right.
Everything is where it needs to be. And this whole issue about Archibald not being there today, that bothers me. That bothers me because he should have been there.
I was just flipping through everything in Chad's portal and going over every hearing that has been held. And I'm not seeing where it says that Lori was watching or Mark Means or Archibald was involved in any of the hearings. Do you guys happen to remember what hearing it was where they straight up said during the hearing that she was watching the hearing?
Yeah. Yep. Yeah. Because
remember
Archibald said, I will have to confer or, you know, talk to my client about this. And he also said in the same hearing that she is watching this. I remember that. That was in one of the last ones with Archie.
Was that like in January, maybe, or
I don't
December?
what month it is today, or I don't know what day it is today. I think it's Friday.
When you got John Pryor saying that Archibald can't file things, he can't file a motion for severance, he can't do this, he can't do that. Well, all along, y'all, I thought, well, it might be in a stay, but Archibald can still do the footwork. Well, as far as John Pryor's saying, Archibald is at a halt right now, and that don't look good. I mean, because Lori hasn't signed a waiver, has she?
Boyce corrected Pryor about that, though, didn't he?
Carrie, your mind is brilliant, by the way.
Boyce corrected Pryor and said that he can absolutely file anything that he wants to file.
Is that what he said? Maybe I missed that.
Help me out, chat. Maybe I got it wrong.
Carrie.
I don't remember hearing that, but you're probably right. I don't usually. Sometimes I have selective hearing.
Well, that's human nature. That's all of us. You could probably find it if you still got it on your TV, Cressy.
Yeah, I'll go back and re-listen to it. But I think what I've really gotten down to the nitty-gritty about on this is, number one, Lori is still incompetent. Number two, it's inappropriate, according to the state, to sever the case just because of Lori's status.
Oh my God.
Can I say something real quick?
Thank y'all for the super chats, by the way. I'm blown away. Yeah, thank you. I'm sorry. Okay, continue.
Can I say something just real quick?
Yes.
If Archibald wasn't allowed to file anything, what the hell was Mark Means doing for the last year?
Filing shit.
He filed 1,000 effing documents.
Yeah, but Mark Means wasn't under a stay either.
Yes, he was.
Are you talking about after Lori got committed? When he tried to say that that some funny business was going on up there at the mental hospital?
Yeah.
Her stay started on 5/27.
Okay.
So everything he filed after that was while she was incompetent.
But yeah.
You're right, Big E.
Wow. Whoa. It's weird when you take it and you look at all different angles of this. It blows my freaking mind.
The whole timeline calendar of the judicial aspect of this in terms of legal documents has got my brain into mush. I don't even know if I can ever recover.
Right? Thank you. That emoji icon with the little head with the brains bursting out of it, that is an understatement. I can't use that big enough.
I've never ever been able to confirm this, but everybody on Twitter had a source that was always saying that even Mark Means was at the hospital with her.
Mm-hmm.
Countless times.
I remember hearing that too. Now this is just hearsay. We're not saying anything.
Right.
Just I gotta do this as a generality. This is just us talking. Okay. All right. Go ahead.
Yeah.
It's our opinions.
But that's why Pryor, Boyce corrected Pryor and said Archibald can file anything he wants. I mean,
yeah.
Well, how about this? Try this on for size. The state today quite clearly said that they wanted a delay because Lori needed basically a say-so in this severance issue. And people might be like, well, what does that have to do with anything? Well, what if Lori's up there? What if they wanted to sever this case? She was say she's back competent. She's back with
talking to her
Archibald.
mom, according to Adam, and that she's just remember that statement from Adam on 2020.
Yeah. Well, what I'm saying is, what if Lori doesn't want a severance? What if Lori wants to sit by her king?
Well, then she needs to shake the hell up and get her ass up to the plate, swing the bat, proverbial.
So John Pryor might want a severance to get away from Lori, but what if Lori wants to stay with old chatty boy and the chin?
That's right.
She likes the chin. The chin is so good.
Oh my word! Let me pause this. Mute this real quick because I'm printing.
It's already gotten started on Twitter, and I'm backtracking here about when y'all was talking about the names and whatnot. Correct me if I'm wrong, but somebody started it on Twitter and pointed out that Pryor referred to Lori as Valo instead of Daybell. Now, I remember specifically that Pryor referred to her as Valo Daybell. Was there another time in that hearing to where he didn't say Daybell? Anybody remember?
I don't remember. I don't.
And your point being, Big E.
The finger pointing is what this.
Enlighten me, educate me, Big E.
It's just the person saying that the way it's worded is they think they're split, Chad and Lori. They think
okay.
Split.
Well, did you hear John Pryor say anything about antagonistic defense? No, but the state brought it up today, did it not?
Which is right here, guys. I really just want y'all to see this. I only read like the first lines into it, and I was like, sounds interesting.
Read it, girl. I want to hear it.
All right. Okay. The upside. All right. The upside of letting go: severance in criminal trials. Probably the only thing worse than being charged with a crime is the trial itself, with its attendant risk of a conviction, jail, and big fines. In some cases, moreover, it is not just the prosecution that a defendant needs to worry about, but a co-defendant who will also be on the offensive against you. It might not be as bad, as the old spy versus spy routine from Mad Magazine, but it does complicate a defendant's and counsel's chance of winning an acquittal. Thus, a defense attorney will often move the court to sever a client's case from a co-defendant's so that the client can be tried separately. Severance does more than just avoid the prejudice of a joint trial. It makes life significantly more difficult for the prosecutor. After a severance, the prosecutor must try 2 or more trials rather than 1. Okay, we know that. Forcing the government to expose its witnesses to cross-examination and to expend additional time and resources. Now, this is from antagonistic, that term that Pryor said that KJ brought up, the antagonistic.
It was the state. The state brought it up. It was antagonistic defense.
Okay. All right. So right here, across. Oh my God, I forget my spot. Rather than forcing the additional time and resources. Moreover, the defendants in the second trial get a rare preview of the government's case against them. Of course, oh my God, there's that word again, flip side. That's a pattern here. Of course, the flip side is that the prosecution can learn from its mistakes in the first trial and clean them up for round 2. One of the most common grounds upon which to ask for a severance is antagonistic defenses. In the textbook case of antagonistic defenses, where each defendant accuses the other of committing the crime, it would be unfair to try the defendants together because they would end up performing the prosecutor's job for her. However, what about those cases where the defenses are not so obviously in conflict? In those instances, it becomes difficult to overcome the bias towards joinder. After all, public policy favors joinder because it expedites the judicial process, reduces court congestion, and avoids the necessity of recalling witnesses. People versus blah, blah, blah. There you go. Moreover, severance is not mandated solely because of its hostility between the defendants, differences in their trial strategies, or inconsistencies of their defenses. Look at that site. Okay, citation. What is it called? Citation? Anyways, recently we faced this bias against severance in 2 very different cases and were able to overcome it. These examples illustrate that the best way to obtain a severance is to convince the court that trying the defendants together will create a nuclear war in the courtroom with the co-defendants attacking each other, and let's add a dead co-defendant in there. In one case, a politician was accused of accepting cash bribes from a local businessman. The politician was indicted along with the individual who actually delivered the bribes, the alleged middleman. That would be kind of, I guess, Alex. I don't know. The politician's defense was that the middleman was pocketing the alleged bribes. Makes him a criminal too. So it was critical that the 2 men be tried separately. Though the court rejected the argument that the co-defendant's defenses were irreconcilable and mutually exclusive. Oh my God, I sound like it nonetheless stated that the risk of prejudice from joinder was great. Specifically, the court found that a joint trial would create a dilemma in which either A, the middleman would face an additional prosecutor in the form of his co-defendant, or B, the politician would be prevented from putting on a full defense. Thus, saying the Lord, no, I'm just reading. Thus, even though we could not make out a textbook antagonistic defenses claim, the court still ordered a severance. In another case, a businessman was indicted along with several colleagues for white-collar fraud offenses. Though the managerial defendants, the managers, denied committing any illegal actions, one of their subordinates had implicated them in pre-indictment interviews with the prosecutors. and other subordinates likely would do the same at trial. Therefore, it was critically important that the managers sever their trial from that of the other subordinates. Citing People versus Caldwell, the managers argued that the subordinates would take an aggressive adversarial stance against them, in effect becoming a second and third and fourth prosecutor. The trial, therefore, would quickly devolve into a fight between the two groups of defendants rather than between the prosecution and the defense. Okay, I get that. The judge agreed and granted the severance, ruling that the managers be tried separately from their subordinates. However, the story does not end there. A couple of months before trial, the defendants received the grand jury testimony as part of pretrial discovery and learned that some managers had undermined another manager's attempts at reforming the company. Thus, it would likely become necessary to inculpate. I don't know.
Exculpate.
Inculpate. I don't know how to say that. These managers in order to defend the other manager, which would create a similar antagonism at trial the first severance had sought to avoid. Faced with this dilemma, the managers requested another severance, this time from each other. Normally, it would be too late procedurally to make such a motion, but the defense argued that the grand jury testimony had provided the aggrieved manager with grounds of which he could not have been previously aware. The judge agreed and granted the motion, making it the rare case to feature not one, but two severances. I wonder if they can sever from Alex. In requesting severance to avoid the prejudice inherent in a joint trial, the defense has to take a gamble and expose a significant portion of its trial strategy. Defendants facing joinder must take a hard look at their co-defendants and decide whether it is smarter to try to go it alone. And if you want to know more, click here. Anyways, I don't know if it's relevant or not. I just, like I said, I just kind of read the first, whatever. It's the first thing I came to, but I don't know. Can they break away from Alex? He's dead. Man can't be at a trial, right? I mean, I don't know.
It's all going to come down to what the evidence shows.
Yeah.
I would think. I mean,
well, like you were saying, Crusha, in your examples there, I mean, there was a middleman who basically done the legwork, and I think Alex was the instrument of murder. So that's just my opinion. I could be wrong.
I feel the same way. And can't they sever from dead man?
No, because he can't be there to be adjudicated. He's just a.
But he's lumped in with this. So how do they break away from him? Is that
they wouldn't break away from him because of the one word, conspiracy. Two or more people act in concert together to do criminal activity. I'm telling you, those situations were white collar crimes and things of that sort. This is conspiracy. How can you adjudicate a case in conspiracy to commit murder if you don't have them both there?
Right.
Or
all three.
Yeah, right. And the evidence, and let's just be clear, Alex is dead, but there's evidence, out there.
Him being told what to do.
Yeah, empirical evidence. It's almost as if he's there as well, if you really think about it, because the testimony,
spirit,
the testimony is going to be there, whatever it's going to be. But
they have the evidence, not including Alex. They have enough evidence to bring 2 death penalty charges with Alex dead. So that puts them hands-on at some point.
And Big E, that's a great point, because the state's not going to reach for death penalty cases.
No,
That's a
they're
hard
not.
threshold
No,
unless
they're
they
not.
got it.
They're
not going to charge that unless they got it, unless they know they can. They're not going to want to overcharge this situation.
No, they are not.
They're not going to want to do that, and they've got to know that they've got all that in. And back to this Arizona thing, let me just say this: the state made it very clear when it comes to jury instructions. The judge can make a ruling. Well, this Arizona stuff's not going to come in at all. Or this is going to be in the jury instructions. If some of it does come in, he can put an instruction in there saying you can't do this or that about this type of evidence that's coming out of Arizona. So the state is showing there are remedies for John Pryor. If John Pryor is like saying, well, look at this situation in Arizona, and maybe he's looking at it from the point of view that, well, the stuff in Arizona, Chad didn't get charged, but there is activity of him talking to Lori during the time that she was doing all this that will make my client look bad. I don't know which way he's looking at it. In my view, I think he's trying to say that Lori and Alex was the ones that did it all, and that his client was, just kind of bamboozled into it all. I'm just saying that there are remedies aside from severing a case. And we're talking about 2 cases they're talking about cost estimates right now. We're talking about over $52,000 just to go and get a jury out of Boise to bring it back to Fremont, which I don't think they're going to get that. What do you think?
Okay, I get it. They're just having to read, but we're having to read between the lines about everything else, but they're really talking about severance. But but they're also.
And you're absolutely 100% right, Crescia. But the one thing that has been signed, sealed, and delivered by Boyce and the Supreme Court is the change of venue. I don't see them walking that back now because it's already been approved at the highest.
Yeah, well, the judge left the door open. He didn't have to. He could have shut the door right then last time they met about reconsideration from the state on bringing in a jury. And he's also ruled after that he's going to give them more time to get the estimates together. It's got to be relevant.
He still has to hear evidence that wasn't included before that they've gotten all of a sudden that seems to sound like is going to make a difference for the state to be able to not move it. But so yeah, he has to do that because that could be an appeal down the road. So he has to consider it, but it doesn't mean that he's going to change it unless he is swayed. But I have a hard time seeing a judge walking that back after it's been signed, sealed, and delivered by the Supreme Court.
What's the difference between getting a jury in Boise and having it in Boise than taking a jury out of Boise and bringing it back to Fremont County?
Money, where the money goes, will it go to Fremont County?
Well, the Fremont County and Madison County is going to have to fit the bill. They're going to have to fit the bill on it no matter what.
They're also going to make money off of this. It's going to, bring people from all over.
The thing is, though, guys, is
and Boise's going to get it.
The change of venue.
Either way, Idaho gets it.
The change of venue is because the county was so small. They moved it so to a bigger populated area.
Right. I understand.
You see what I'm saying?
I do. I get that. It's just like you try to take it all into perspective by looking at the big picture. But it is, at the end of the day, I don't care who you are. I always say, what is the end game? What is their end game? It's not just to salvage or, save us from having to deal with it over and over again. It's money. Money is the root of it all. I don't care. That's my opinion. Who does it benefit in this argument? Who? I don't know.
Well,
I wasn't bitching. I was just,
well, no, I'm just trying to come up with a
yeah,
solid answer for you. I
it's
mean,
just something to reflect off of, when you're thinking about and when, asking these questions and these court hearings, a motion to sever, motion to whatever. It's just like, and whose best interest is it for, really? Who is it? What does it come down to?
Well, Kathy says that, in her opinion, it's more expensive to transport all the players than just the jury. And that's a good point, because if you think about it, you got to think about the sheriff's department, you got to think about court reporters, you got to think of all that stuff moving to Boise, or you just bring the jury back and sequester them in a hotel. Which is more expensive? We're talking 10 weeks.
Crew, the whole
10
crew.
weeks.
The whole crew's more expensive. The whole staff.
And the judge will make a decision on it. What, on the 20th? Is it the 20th of April?
I don't know. I mean,
yeah.
does he have to make a decision? Does he have to wait that long?
Right. I mean, that's when the hearing is set for it.
Yeah, they're giving Rob Wood. They're giving Rob Wood a little more time to get the estimates together. And the judge will make a decision on it. And then that'll be something less that we even have to talk about, because one way or the other, I'm going to Boise or I'll go into Fremont, whichever one during the trial. Either way it goes, I'll be there.
Edie Rue says, KJ, get that RV revved up, lady.
I'm getting it. And I already talked to you, Crescia. Yeah, I did. I'm just serious as a heart attack. I
am too.
You haven't seen this RV. It's 40 foot. It's got
I just want to see you. I'll look at your RV. I'm sure it's really cool, but I really want to see you.
I got enough appliances inside that Jason can cook me my crawfish.
Well, that'd have to be outside the RV, but that's okay. You don't want us boiling crawfish inside your RV.
I don't know how crawfish is made. I just know it tastes good.
You're gonna learn. You'll find out.
And I meant to post that song for you and Jason last. I did, and I completely forgot about it. I got busy doing something else, and you know how scatterbrained I am.
I know how I'm the same way, and that's why God made it tomorrow.
Yeah.
So.
Yeah, definitely. But hey, listen, y'all. If we didn't have each other if I didn't have like your optimism, Crescia, and Biggie's level-headedness, everybody on this, Kathy, Joe, Pa, Sarah Adams, Snickers, Rainy April, Carrie Livingston, Zero, Tracy Wendover, the Betty Boops, Sarah Adams, Bo Peep, Sam Willow,
Carrie, everybody brings so much to the table, and I know I appreciate it. It's so needed. I can't imagine doing this without a community. I don't know. I'd probably be dead myself, because my mom would have done strangled me, because I'd have been asking her 50 million questions. And then she also, I think does the same thing. What's going on? It's so weird. There's so many different angles, so many different people bringing up different aspects of it is voluminous. Okay. Portions.
I still have one major question that I wanted to throw out to the masses, if that's okay.
Okay, go for it.
If everybody is on their phone listening, go to Google and type in Idaho Rule 25.
Okay. I'm not going to do it because, well, hold on.
Well, yeah, you can do it.
On my too.
Hello.
Hello. Okay. I apologize for being so loud in the background. That microphone really does pick up sound. Jason was snoring. Anyways, so we're Googling wrong app.
Idaho Criminal Rule 25, ICR 25.
Okay. The motion to disqualify?
Mm-hmm. My question is, does Chad still have this throwaway judge for no cause
Oh yeah.
at his dispense?
Okay, what he's referring to is whenever Lori first came, was extradited, and Judge Farron, my favorite, Edens, was her judge, but he was a magistrate. See, I don't understand all that, how that works. Magistrate, and then it moves up, right? Just keep that in. I don't really know how to explain it because I don't speak legalese. But Lori was able to choose to,
She used her.
She was able to say, I don't want this judge,
Right.
And so
She
got Judge Mallard.
She used her chip. So that's why I wanted to ask everybody, because I read this about 15 times last night, and I was tired and it was late. But I kept it reads, and then it circles back to you got to read something else to.
Oh yeah, no. That's how I figure out their belief system thing. That's how I can do a legal from the legal aspect. That's not my cup of tea.
Are you reading it, KJ?
I'm not reading it. I'm listening to y'all's comments. This is what I think. I think that there is no way, absolutely no way, after Judge Boyce has already petitioned the Supreme Court for change of venue. He's been on the case. There is a scheduling thing that goes on with pretrial. They're past all that now. That's what I think. I could be wrong, but I mean, and they would have to have a reason. Not just, because there's this rule in here that says you can toss a judge.
No. That's inaccurate.
She had to have a reason for, she can't just toss him for nothing.
Let me read it to you. Disqualification of judge without cause in all felony and misdemeanor criminal actions, except actions before drug courts or mental health courts. The parties each have the right to one disqualification without cause of the judge. And
Lori, I mean, Judge Edens was
he was going to recuse himself anyways because of the conflict of interest. Because
right.
Yeah. I don't know how to think about this.
It's a jacked up law, KJ. It is a jacked up law, but I was hoping you was reading it. That's why you were so quiet.
Maybe after, whenever we get off here, because I mean we're on approaching 4 hours now. I think that we can reflect off of this question, and then we'll be live Sunday.
I still think Judge Boyce could not get kicked off. That's just my opinion.
Right? Yeah. And then because that would be a cluster F. Okay, because then Chad could do it, and then if Chad, anything you can do, I can do better. They're extra, so holy shit, that'd be a shit show.
You know what's interesting, Big E? You know you want to know what's interesting about that rule, Big E? That Lori was able to get Edens taken off, and yet she was competent enough to do that. And
she can do all kinds of things.
Yeah, she can do all that.
She talked to her cellmate about how she was just so effing important that Colby Bryant was killed and coronavirus, and there she is about to do her grand entrance and go smile in front of my parents.
You see that right?
She was doing this. She was flipping everybody off.
You see that comment right there?
Which one?
Carrie Livingston is on point.
I wish Carrie Livingston would come on here.
Because that's exactly correct. They have already assembled.
Well, read it. So
back judges. She says, I thought you could see. I'm sorry. It says, I remember reading something from Idaho Supreme Court, where they gave multiple backup judges to Judge
Yeah,
Boyce in this case.
I remember that too.
Yes, and Judge Boyce specifically asked the Supreme Court that he stay on the case.
Right. But that still doesn't mean he can't be removed.
I disagree. I disagree at this point, but that's just me disagreeing.
We can, you know, I don't want to ask another attorney.
I mean, you could be wrong.
I want to figure this out on our own. I love it.
That's why I wanted to throw it out to the mat. I mean,
let's marinate in it, and then Sunday when we do our regular Sunday live stream, we can address it if you're all okay with that.
Because, like you said, but I mean, it just makes sense because they have the setup that John Pryor can do all the legwork for 2 years, and when the trial starts, another lawyer can come in and sit down. So
yeah, but he's basically he's so knowledgeable on it, you know.
Right. Well, I'm just
I really
saying
don't understand all that.
Laws in Idaho, really jacked up laws in Idaho.
I guess we'll learn per victim, per murder case.
Well, just be glad there isn't an insanity defense.
Yeah, right? No shit.
I mean, it can be considered in mitigation, but for sentencing. But the bottom line is I'm finding out a lot of jacked up stuff. I'm finding out things that I didn't know, and Big E's giving me something to think about and to research.
Mm-hmm.
I always do the wrong thing, I think, and that is always go with my gut feeling before anything else.
No, I think you're wrong about saying that because your gut feeling is correct.
Exactly.
Trust me. Exactly. I have spent my entire life up until all these this happened. I tried silencing and muting and not listening to my gut feeling, and that's why I was doing my own form of insanity. Okay. Doing the same thing over and over again, expecting different results. And that is insanity. And so your gut feeling is on point. Always listen to that. So it's right. It's right. And I feel it too. I feel it. I feel she's competent. And I have. I feel like she's been using this just like she has done every single thing else. That is the pattern. That is that's her signature. That's who the hell Lori is.
That's her MO.
That is it. That is it.
If anybody would know that, you would. I'm just saying that this whole situation with us not being able to be generally told what her status is, and that the state wants to sit there and say they don't know, and the defense are sitting there scratching their head.
It's like a chess game.
I was going to say something else, but I thought, well, I don't care.
We filled in the blanks.
Only on my channel will I say things because I erase them anyway.
You can say whatever the hell you want here.
Well, John Pryor looked like he had a set of itchy balls, okay? He sat in that chair. I want y'all to go back. I want y'all to look at John Pryor. He looks like he's got maybe, I don't know, jock itch or something.
Maybe the hemorrhoids.
Yeah, right. Maybe all I know is he just like some of y'all were saying, I was cracking up. He needs to go get him a stiff drink. He needs to go pour him one tall boy or something. I don't know.
It's a drink in one hand and some freaking blood pressure pills in another.
Right.
And I'll send him some we'll send him some hemorrhoid whatever, jock itch cream.
Yeah, he's got that Jim Blossom look, doesn't he? He's got that lush look, he's got that
always.
And Chad looks so defeated. Y'all notice that? Chad just looks so defeated sitting there. Yeah, he's smirked a little bit.
They are shells.
I mean,
they're the zombies.
Did you see the coloring in his skin?
Always. It's gray.
It was awful. It looked like he was on the edge of death, and maybe, I don't know. Maybe Bubba's been pouncing him on his knee too long.
Bubba pouncing the portal.
Oh, this has been a really good live stream, Crashing.
It's insightful, you know.
Just to let y'all know, be on the lookout for a Ray Room on the Fly. I don't know if it'll be today or tomorrow, but just be looking for it. I get a wild hair and start researching what Big E's dang saying about this, and then I'm gonna have to bust a move or something.
Brings up.
I'm genuinely asking for clarification because
well, you make a lot of sense, and I would love to agree with you, but I just
can't be
don't
on the
see,
spot, you know.
I just don't see Judge Boyce being taken off the case. I just don't see that. That's not a defensive. I mean, that's strategy. You got to tie into that a speedy trial stuff and how long these waiver of a speedy trial and all this other, because they sign one every 6 months.
And it has to be for it to happen. It has to be done in a certain time frame and before certain hearings. And I mean, it's not a really, really long article or nothing, but it's IDR 25, KJ.
How relevant though is it to the case, or do you just think it's just going to pop?
I think it's very relevant. Big E brings up a good point, though. Really,
if it comes up, you know, and they want to throw that in, let's say in October, because November the 9th is when the pretrial hearing is, because I specifically remember reading that.
Ooh, okay.
One of them is one of the time frames was before pretrial.
Are you saying it's ICR 25? Is that what you're saying?
Yes.
Okay. I thought you said something else. I wanted to make sure it was Idaho criminal rule. I'll definitely. Hey, I can admit when I'm wrong, Big E. In fact, it's when I'm wrong that I learn what's right, and then I can say I'm right. You know, after that.
Exactly, and I like that too. It's constructive criticism. I'm all about it. You know,
it helps me to think of things that I wouldn't be able to think of myself. I mean, Christian, you're always saying things that trigger me. I mean, trigger me into good things.
Well, good.
You know, it's like she just said something that really I need to go check this out, and it might trigger something totally different than what you're talking about, but for some reason it just works out that way. This community's pretty damn awesome.
I feel like, and I have always felt like Tylee, JJ, and Charles, they guide me. I just literally will pick up my phone and just end up somewhere, and I'm like, oh wow, you know. And I mean, of course God, you know, but I don't know. It's the weirdest thing, and it's the coolest thing, but it's just it. And I don't know.
It's your love. It's your love for them, you know, and love is God, you know. I mean, I'm not saying you're God. I'm saying
love is God. God is love, and love always wins. Boom.
Right.
There it is. God wins. Love wins. Good wins.
Yeah.
Ooh, that was my last name.
I think that you know, all we can do is continue to seek justice.
To understand.
Yeah, and do what we can, and we couldn't do it without each other. I'm so thankful that y'all even give me a chance to even say anything, and
same here. So, with that being said,
love all y'all.
Keep on looking. We're gonna go, guys. Love y'all.
Talk to you later.
Bye.
Bye.